Good afternoon, everyone. This hearing is in the matter of case number CFI 072-2022, held before His Excellency Deputy Chief Justice Ali Madhani. The claimant is represented by Gately UK LLP, DMCC branch. Lead counsel is Mr. Mohinderpal Sethi KC. The defendant is represented by Clyden Co LLP, and the lead counsel is Mr. Gavin Mansfield KC. Thank you, Your Excellency.
Thank you very much, Said. Good afternoon. If you are appearing from London, must be good morning. Mr. Sethi and Mr. Mansfield.
Good morning, Your Excellency.
Yes, your application, Mr. Sethi. If there is any other housekeeping matter before we start?
If we could just check on documents that you have before you, Your Excellency. You should have a application hearing bundle.
Right.
Which comprises about 621 pages, digital pages.
Yes, I do have the bundle open before me, yes.
It may also prove necessary to refer to the trial bundle, which has been uploaded onto the DIFC court system as well. Do you have access to that too, Judge?
Yes, I do have it.
And that comprises 1,577 pages.
Yeah, the one dated 6th of December 2023, yes.
Yes.
I just turned it on and I have the two bundles open before me, yes.
Very well, that should be the main documents bundles that you need to refer to. The claimants and defendants' skeleton arguments for the purposes of today's application are contained in the application hearing bundle itself, together with the case authorities referred to. There are one other matter, and that is that I think the pagination on the application hearing bundle has gone rather awry. I'm not sure exactly technically why, but my solicitors have filed and served a bundle reference list. Can you confirm, Judge, that you have that?
You mean the hearing or the application bundle?
The application bundle.
No, I think I'm having normal pagination. I have no issue with this.
Well, let's see how we go. I think if some of the page numbers are inconsistent, then that might be explained by the need for the recent index that's just been, or the helpful reference list that's been provided to the court.
It's I think we should manage this as we go.
I think so.
Yep.
Well, Judge, this is my client's application. I act for Mr. Mohammed Olayinka Lawal against the defendants, Commerzbank, AG, DIFC branch, and or representative office. He brings a claim of a number of claims against the defendant bank. They are principally discrimination claims. He brings numerous claims of harassment under Article 59(2)(c) of the employment law, of direct race discrimination because of his skin color, black, and his Nigerian ethnic origin under Article 59(2)(a). He also brings claims of a failure to make reasonable adjustments due to a disability and of disability-related harassment as well. So there are two types of harassment complaints: race-related harassment and disability-related harassment. He brings complaints of victimization for having done protected acts, and he brings whistleblowing complaints in relation to pre-dismissal detriments and his dismissal as well, in addition to a number of other contractual and misrepresentation matters. But for the purpose of today, we are primarily focusing on broadly speaking, the discrimination claims. So he brings quite serious, very serious complaints of race discrimination, race-related harassment, victimization against his former bank employer. We have trial listed in this matter coming up in towards the end of the month, and we are at the stage of having exchanged witness statements. Certain documents appear to be relevant or sufficiently relevant and it appears that it is necessary for the fair disposal of the claim, this being a highly fact-sensitive discrimination claim, where claimants often have a great disadvantage in proving the basic facts and persuading a court to draw adverse inferences that something was motivated by race, when obviously parties won't readily admit to that being the motivation. It could also be unconsciously motivated. And that's why in cases like this, we say that it's all the more important that there is fuller disclosure where something is relevant or sufficiently relevant to the issues to be determined at trial. So it must be, we say, remembered at the outset. This is why I stress the point that this is a discrimination claim. It's the first discrimination claim that will be heard under the laws in the DIFC, and it is important that we say that we get off on the right footing in terms of having sufficient disclosure in the case, and not to have any satellite issues of disclosure or appeals arising therefrom. In short, our position is, before we get into the detail of the application, our position is that there are some clearly relevant or sufficiently relevant documents which are necessary for the determination of the issues in a discrimination case, which is so fact sensitive and relying upon drawing nuanced inferences of discrimination. And the disclosure at this stage is not going to upset the apple cart. We're not going to, it doesn't cause any severe prejudice. It doesn't prejudice the length of the trial. There aren't any material significant further witness evidence that needs to be obtained. It is relatively minor. And indeed, it's the kind of documents that if they came to light mid-trial in a case of this kind, a court may well of its own motion wish to have before it those documents in unredacted form where they, on the face of it, appear to be sufficiently relevant. So without further ado, we say that this is an important application in an important case. In terms, Judge, of the procedural background, just before I do, I should just add for the record that I think at paragraph 3.1 of my skeleton, where I tried to summarize helpfully the claims by reference to the particulars of claim, that's not a complete cross-referencing in paragraph 3.1, particularly subparagraphs 1 to 4. Those POC, particulars of claim references, will change. They were
Mr. Sethi, if you allow me, I think one of the hurdles you should try to overcome in this hearing is a central point. And before you get into the test whether this is a materially relevant document and that it has to be in the bundle, I think you would have to deal with the timing of making this application at the beginning. As from Mr. Mansfield, it is too late. I mean, one of the central points is that it's too late to make such application. And if it's if it's too late, then we don't have to go and to deal with anything else. You know what I mean? And I think the waterfall suggests that you need to convince me that it's really not too late. It's not going to jeopardize, I mean, the proceeding, the other factors that are related to the hearing in 10 days' time.
Can I just say this, Judge, on that? And that's the reason why I mentioned what I did briefly at the outset a few moments ago. The first point, and I say this advisedly, that it is never too late to seek production of sufficiently relevant or material documents, especially in a discrimination case. So that's my first point. It's never too late. So yes, there is a criticism. It is not fully justified. It's somewhat, I can see why my learned friend makes it. He sees a technical point, he wishes to take it, and quite rightly and understandably, he should do that in his client's interests. But it is not a as it were, if one side is slightly delayed, if we've delayed, not that we necessarily have, I say, but if there has been some delay, it is not some kind of trump card or get out of jail free card for a defendant who has relevant and probative documents to the proceedings, particularly where disclosure of them causes little or no prejudice for that application to still proceed. So there are 2 points. One, I say it's not too late. And secondly, I say, even if it is technically in breach of a direction, that is not the test. The test would be whether a fair trial of the issues can still be had, whether the matters are relevant and probative, can still be produced and dealt with. And as I say, and as I've said in my skeleton argument, my learned friend takes these technical points, and I will deal with each of the technical points he raises. I don't believe they are determinative points. And in particular, there's no particular inconvenience or extra expense, which is inordinate, or delay to the proceedings, or prejudice or oppression, which is going to be caused to the defendants in having to produce the documents at this stage. So, and one of the factors that will affect your exercise of your discretion, Your Excellency, is that even if it is late, let's say, for a moment, let's just say it's late technically, but if you can't just decide the application then without actually seeing how relevant, how necessary or desirable it is for these documents to be before the trial judge in a fact-sensitive discrimination case, because you could just be shutting the door without actually seeing the importance of the documents to the resolution of the pleaded issues. And so if this was the right way of doing it, then there would always be, somebody in my position would always be faced with the point that, well, you're just too late. And then one wouldn't look at the substance of the application. So I think in one sense, one should come back to the timing at the end, not to ignore it, but we have to grapple with it, but to deal with it in the context of the importance of the application. As I say, these documents might not be.
You're saying the importance of this document, and from fairness point of view, it should overweight any lateness if there is any.
Yes, it's a question of balance. It's a question of exercising your discretion judicially and judiciously, and the balance is often as to whether a fair trial can still be had, and whether there's insurmountable prejudice caused to the other side, and the central importance of the such documents to, as I say, it's a label often used, but a very important one in relation to highly fact-sensitive discrimination cases, which are often turn on the drawing of adverse inferences as to motivation, based on a number of primary findings of fact across a number of documents. So it's a very nuanced.
Okay, would you please tell me this? I mean, we were like, the trial is just short falling, a matter of 10 days. I mean, you asked this court to order the other party to produce the documentation. We didn't know how long that would take, and then we have a bit, as I said, complicated trial sort of, and you just said we do have a tight program for the hearing. We do have witnesses, cross-examination. We have counsels. I mean, getting prepared for the hearing, for the cross-examination and the hard work. I mean, where this process would fit in. I mean, we don't order someone to produce, take it on board, deal with it in your pleadings, prepare it for the cross-examination. Can't you see any complication, Mr. Sethi, in this?
No, because of the nature of the documents that we're seeking production order for. They're not the kind of documents, Judge, which requires some kind of new inquiry of witnesses and a whole load of extra effort to change the nature of the trial. And let me explain that. Let me really deal with that on its straight on. So, for example, the first 3 document requests are for grievance documentation that was our client is a senior manager in the Dubai branch. He's brought, he himself brought serious race grievances against his employer to his employer's attention. He knows that other other senior black of Nigerian ethnic origin, just like himself, managers of the branch and the bank, have brought similar race discrimination complaints to the bank's attention in the form of grievances. Okay. All my client is seeking, and my client pleads and evidences in his witness evidence, and the other side have dealt with it in their response, as to whether there is a discriminatory culture within the workplace. In other words, whether black and Nigerian ethnic origin staff feel welcome and equally treated in the workplace. And what has happened here is that there's two points here. One is on the timing, impacts of timing, and one is on the nature of the document sought. On the timing point, it wasn't until exchange of statements that you see the other side, the defendants, completely denying that there's any discrimination, race discrimination problem in the workplace. Okay,
the culture,
the culture, the discriminatory culture in the workplace, the toxic culture. They completely deny it. They say, I've never seen any such evil. I've never heard any such evil. Okay, we're a completely discrimination-free organization. That's the first point. The second point is they're completely silent. And we didn't know this until the witness statements were exchanged. They're completely silent about the existence even of other race discrimination claims, particularly those brought by black senior Nigerian ethnic origin managers at the branch and the bank. That's surprising. So the issue of whether there is a discriminatory culture or a toxic culture, at least from the perception of black Nigerian ethnic senior managers, is a live issue in the trial. Now, the second big point that I come to, which is why this doesn't derail matters going forward, given that the trial is imminent, as Your Excellency rightly identifies. The reason why it shouldn't be a problem is, and the other side have misunderstood how we're going to rely upon those three grievance documentation. They say we want to rely upon hearsay evidence. They say we've not, because we're relying upon the contents of those grievances for the truth of those allegations contained in their grievances. We're not at all. What we are relying upon is the fact of those grievances being brought, simply the documentation itself on the face of it, what it says, the allegations, the complaints, to show that other black senior Nigerian ethnic origin managers, including, Your Excellency, may I add, Mr. Odonai, who was the claimant's line manager. All right. So the claimant's line manager also makes similar or same race discrimination complaints. He's black, he's Nigerian ethnic origin, he's in the same branch against the same people around the same time. And the other side clearly don't want that documentation to be in a public hearing before the trial judge, because it would tend to show that other people who are close to the same situation as the claimant have very similar concerns as the claimant had about direct race discrimination and harassment and victimization. Now that, Judge, when I put it like that, I hope it's appreciated. It's directly relevant. It's absolutely relevant to my client's pleaded and evidence case of a discriminatory, toxic workplace culture. Now, we don't want to, we're not about proving that the other people's complaints were right and well-founded. That's not the point. The point is that there are other senior managers connected with the claimant, connected with the branch, connected with who are black, who are of Nigerian ethnic origin, who took it upon themselves at around the same time to submit formal, serious allegations of race discrimination, similar or same to the ones that the claimant has, which is the subject of this litigation. That's obviously probative of the background culture.
You're talking about the importance of the evidence. Well, I understand your point. I mean, why that's important to you. But what I'm saying, and this is a new evidence hurdle for Mr. Masfield. Well, he need to deal with it. There is no time to deal with it, not time to prepare for it. I mean, you know what I mean? To contain it in his submissions. I mean, to.
No, Judge. The point is this: we're not seeking to prove that the race complaints that other people brought were well founded. In other words, whatever the subject matter of those other complaints are and who they complain about, they don't need to try and defend those complaints. All we're wanting before the trial are the contents of their complaints and the related documentation. That's it. Those documents, Judge, speak for themselves. Now, no one's admitting the truth of those documents, but it's the fact of those complaints and the nature of those complaints made, and against whom they were made, and at the time that they were made, which are very similar to the claimant's complaints, and that would evidence that within the perception of other senior black Nigerian ethnic origin managers in the DIFC branch and the bank generally, there is a concern, a perception by them, whether it's right or wrong. We're not trying to prove that, but they believe that there's a serious problem of race discrimination here against them. That's all, and that helps to establish a key relevant point in the case, which is pleaded and which is part of the evidence matter in the claimant's witness statements and the respondent's witness statements, that as to whether there is a perception by some of a toxic discriminatory workplace culture. It doesn't require any instructions to be taken. It's just the actual grievance documentation that we referred to in the draft order that we seek to put before the trial judge. So we're not looking for a whole new line of inquiry. It's simply the face of those documents that we seek to adduce in evidence. They're clearly relevant, or at least sufficiently relevant if we want to have an argument about relevance. And they do go to assist the tribunal, especially in a case where they'll be drawing inferences based on the complete circumstances as to whether discrimination played any part in the detriments of which the claimant complains. So, Your Excellency, does that answer the concern?
In your opinion, would that trouble Mr. Mansfield to produce and prepare and get ready to deal with such documentation during the trial?
The reason why Mr. Mansfield makes the point he does is because I understand that the defendant misunderstands the basis upon which we seek to adduce the evidence. He says we're seeking to rely upon it as hearsay. We're not. I want to make that absolutely clear. We're not seeking to rely upon it as hearsay. What we're seeking to rely upon it as simply evidence that other people similar to the claimant brought similar complaints of race discrimination against this branch at a similar time, and that helps to that goes to the issue of whether the black Nigerian people perceive there to be a toxic discriminatory workplace culture. It's clearly relevant, of background relevance, but clearly relevant to the probative of the pleaded claim. Of that, there can be little doubt. In all cases of discrimination that Mr. Mansfield and I do, we see matters of background relevance of this kind, because that is often where courts are assisted by understanding the fuller, more nuanced picture. When
so
making
you're saying no time management risk?
No.
That would risk the fair conduct of the trial from the defendant point of view. That's what you say.
That's absolutely my point. And if there was, we would have had that spelt out. All I'm saying is there just happens to be these complaint documents that have been that are recorded and filed in the defendant's HR system. We simply want disclosure of that, and it's the nature of the complaints, the nature of the allegations, the nature of the complaints that we want to have before the court, because they are directly relevant and overlap with the claimant's situation, and therefore it's probative. No one is asking the court to go off on a frolic of its own and start to decide other people's complaints. I'm only here to decide the claimant's complaints, but it's the fact and existence of what the complaints that were raised by them say. That's all. That requires no investigations, no lines of inquiry. It's just disclosure of those documents that we've specified. Which should be relatively straightforward.
One last question in this line. When you are expecting the delivery of this document?
Well, they ought to be able to email it to us relatively quickly. They've known of the documents that requested, because we've sufficiently specified and identified the documents and categories of document. They're presumably all held in one file, each of those grievances. It'll be relatively straightforward. I understand and fully expect. I'd be surprised if we heard today that it's going to be difficult to retrieve and to disclose these documents to the claimant.
But not to that extent, Mr. T, but I'm saying within like 2, 3, 4 days, 5 days. I don't know. You tell me.
I would anticipate that the other side have already, because they know the nature of the application, they have the documents to hand, and that they can disclose them relatively forthwith, or within 24 hours or so. I don't understand why there would be any difficulty in any time delay built into their needing to, if they were to disclose the documents or be required to.
Okay, I see. I think, yeah, I've heard enough from you on this point. You may continue the test. I'll be back to Mr. Mesfield so he can spell out what he think about it.
So, if I could, it's important that both my learned friend and I broadly agree that the approach of the court is reflected and can adopt the approach of the High Court in England under the CPR, albeit that the nature of standard production is different to standard disclosure in the CPR, fully cognizant of that. But nevertheless, when it comes to document production order applications, they can be treated in a very similar way, if not the same way, to specific disclosure application orders under the CPR. So, Judge, as you know, where a requesting party such as the claimant considers that the defendant party's objections to production aren't justified, then we can apply for a document production order under Art EC 28.36. And that's what we seek, in order that the defendants produce documents or classes of documents that are clearly specified in the order under 28.39 subparagraph 1. Now, in deciding whether to make this kind of order, the court will take into account all the circumstances. So not just the timing of it, but all the circumstances. And in particular, the overriding objective, because that's primarily what this order seeks to serve. Now, the rationale behind the discretion for ordering specific disclosure directions is that the overriding objective obliges the responding party to give access to those documents which might assist the requesting party's case. And we know that from the Exeter City AFC case, which is at my authorities list, tab 2, at page 449 of your application hearing bundle. You don't need to go to it, but I just give you the page number. It's 449. We know that general guidance has been provided, which is well established from the Court of Appeal in England, in the Canadian Imperial Bank of Commerce and Beck case. That's at my authority, tab 4, which is page 473. And there, Lord Justice Wall held that, he said this: in our judgment, the law on, this is at paragraph 22 of that judgment, in our judgment, the law on disclosure of documents is very clear and of universal application. The test is whether or not an order for discovery is necessary for fairly disposing of the proceedings. So it's about fair disposal. Relevance is a factor, but it is not of itself sufficient to warrant the making of an order. The document must be of such relevance that disclosure is necessary for the fair disposal of the proceedings. So, and that's obviously because, and that's why we have the language of sufficient relevance in the rules. Equally, it says, he said, confidentiality is not of itself sufficient to warrant the refusal of an order and does not render documents immune from disclosure. So, for example, if my learned friend was to say, well, Mr. Khan or Mr. Odenai or Miss Akinogu's grievances are confidential to them, that would not be a bar to disclosure, of course, if it is sufficiently relevant and material to my client's case. Now, of course, fishing expeditions are impermissible, but we're not fishing here. We know that these other black Nigerian ethnic origin senior managers like the claimant made similar complaints of race discrimination. So it's not phishing. We know that, but we don't know the details of it, because in Mr. Khan's case it's been redacted, and in the other two cases no disclosure has been given at all. And we understand that the other side would not want to necessarily advertise the fact that other Black Nigerian ethnic origin senior managers have made similar complaints against the bank as the claimant has. Particularly, Judge, given that, for example, in Mr. Odenai's case, his matter was settled, presumably subject to confidentiality terms and a gagging order. But the reality is that you can understand why the bank would not want these documents in. They're uncomfortable for the bank, but nevertheless, they are very relevant and probative here. And of course, the same would apply in respect of any request for provision of information, assuming that the request relates to a matter in dispute between the parties, whether or not the matter is contained in a statement of the case or pleaded. It's about relevance. And when it comes to relevance, one always looks to the pleaded case. And one of the points my learned friend makes, he says, well, we don't see institutionalized racism pleaded. Well, I make 2 points to that. One, actually, there are references in the particulars of claim and the reply to defense and my client's first and second witness statements to discriminatory culture and workplace toxicity and effectively aspects of institutional racism. And I can take your Excellency to the various references. But even if there wasn't, let's imagine for a moment there wasn't any references. There doesn't have to be. In a race discrimination claim, as my learned friend knows full well, the pleaded case are the causes of action, whether it's direct race discrimination or race-related harassment or victimization or whatever it might be. Those are the causes of action. The evidence in support of those causes of action might rely upon institutionalized practices or structures or a discriminatory workplace culture to show that there is a context, a background, and evidential circumstances in which such behavior has been condoned or allowed to get away. People allowed to get away with it without any sanction. Now, that's often, invariably, in fact, a matter of evidence, and that clearly is in the evidence in this case. So it is an arid debate to try in a discrimination claim like this to suggest that, well, some form of institutional racism has not as itself been pleaded. And the point is, it's not a cause of action. Institutional racism is not a cause of action. So you wouldn't expect that to necessarily be pleaded. But there are references to it, which I'll take you to in a moment. But the next point I wanted to just raise is that the overall test for disclosure in this kind of circumstance, it could be seen as analogous to that expressed by Mrs. Justice Eadie in the Flood and Times newspaper case.
Before we go that far, I mean, we're understanding, like the sufficient relevancy of the document should be tested against the cause of action or the pleaded case, isn't it?
Yes.
That's how it works.
Yes.
Well, we need to understand what is the pleaded case based on what cause of action, and then the evidence should be relevant to these facts, isn't it? I mean, I have explored the part of a claim, and if you could just refresh my memory, if you can take me to a direct race claim of the claimant himself, not the culture.
Yes.
Direct discrimination and direct race in 2 short examples, just to remind myself for my reference.
I can give you a series of references,
yes.
Judge. I've got a long list, and it may be that my solicitors could email this to you so you have it on screen. Would that be helpful? You then have it in black and white. I'm just going to take instructions to see if I can send that to Your Excellency.
But I remember 2 exotic.
Yes, there's quite a number. There's quite a number, but
Your Excellency, I don't want to interrupt, Mr. Sethi, but I would have thought the best place to start in the light of Your Excellency's question would be what the pleaded case actually is. And you'll find the race discrimination claims at page 17 of the application bundle, paragraph 6.1 and onwards.
Yeah, paragraph 6.1, you mean?
Yes, so if you go to paragraph 6.1, Your Excellency, in the particulars of claim, it's page 17, as my learned friend says. There, you wanted some examples. So
Yes.
we see an example of harassment there at 6.1.1. This is Oliver Kern, a former chief operations officer of the first defendant, stormed onto the trading floor, scolding the claimant in a manner intended to degrade, humiliate, and demean the claimant in front of the entire office. And the claimant says that behavior was condoned by the bank, despite it being in direct breach of the bank's company code of conduct, etc.
Right, but this is nothing to do with the documentation in hand so far, yes? This is another one.
Well, if you want to see something that directly refers to the Khan grievance, for example, Mr. Khan's grievance and reliance upon that, if you go to the very next paragraph, which is another direct race discrimination detriment complained of, 6.1.2, Mr. My clients, the claimant says, in 2016-17, Naj Khan raised a grievance and filed a discrimination complaint seeking to demonstrate a pattern of discriminatory practice, setting out he had witnessed the claimant being racially discriminated within the work setting. The claimant understands Mr. Khan set out that it was unfortunate that the claimant suffered such treatment despite being a top performer within the bank. So let's just pause there. Just one example, okay? This is the first document request, by the way, the Mr. Khan's grievance documentation. It's full, central, pleaded part of the claimant's case that he's relying upon this complaint raised by Mr. Khan for the purposes of his direct race discrimination claim.
Yeah, not based on hearsay evidence, but it's a written evidence that's in the documentation required by you.
Yes.
Yes.
And then you've got the two exotic example next to that. These were comments made in the workplace, which we say is racially derogatory, people allowed to get away with it because that was part of the cultural circumstances of this workplace. The next one is a discriminatory relocation offer at 6.1.4. But there's a long list of direct race discrimination, race-related harassment, detriments, victimization for raising race complaints, detriments, as well as others. And I can supply Your Excellency with a full list if that's of assistance.
I think that's sufficient for me. Yes.
And Mr. Odenai, remember, Mr. Odenai, the second grievance, I mean, it should not be lost on the court that he was the claimant's line manager, right? And he is also black like the claimant. He is also of Nigerian ethnic origin like the claimant. He also raises race discrimination grievances like the claimant. The claimant complains of a toxic discriminatory workplace culture in his branch, in his business unit. The existence and nature of his line manager's race discrimination complaints is absolutely directly relevant. And let's imagine, Judge, for a moment that this transpired and only arose mid-trial. You know, somehow no one knew about this, and it came to light that his line manager had raised a race discrimination complaint at about around the same time, similar types of allegations, although the nature of the allegation won't be known until you look at the complaints themselves, of course. In my humble submission, most judges would order the defendant to disclose the existence of those documents and the nature of those documents so that they could be read, because they are, on the face of it, directly relevant. Now, of course, if it transpires, Judge, and this is the other point another big point I want to emphasize, the authorities that I'll take you to in a moment do caution against, at a preliminary pre-trial stage, excluding evidence that might arguably be relevant or sufficiently relevant, because you don't really know its probative value in a fact-sensitive discrimination case unless you're in the thick of trial. Now, it might be that, and what I would suggest we do is that we do order disclosure of these matters, and the judge at trial, if they are disproportionate, always has the discretion to exclude it then. But they will do that from an informed perspective, not from the perspective of, oh, it just happens to be slightly late before trial, and I don't fully know the relevance of it because, of course, I haven't seen the documents. Remember here, all we have is a highly redacted Khan grievance set of documents. We have no disclosure whatsoever of the Odinai and Adioko documents. I think I've mispronounced her surname, but it's Grace is her first name. So the court needs to see it really to understand the relevance of it. Otherwise, what you've got is the defendant hiding behind the technicality and not allowing the court to see something which is potentially highly relevant. And as I say, that is the other point. So these can easily be disclosed. They cause no oppression or prejudice. It doesn't derail any trial timetable. We can get on with it. And it is directly probative and relevant. But if it turns out they are not of any relevance, well, then they can be excluded by the trial judge or an application made by my learned friend on day one. But the reality is we are, on the face of it, aware that these documents are of clear relevance, we say, or at least sufficient relevance if we want to go to that level of test. Now, Judge, it is important to just on this point understand the guideline authorities. At paragraph 6.7, I refer to the flood authority, which essentially sets out a three-stage test. It says the question is essentially to be asked in each case whether the documents are likely to help one side or the other. And importantly, Mrs. Justice Eady stresses that the word likely in this context has been considered by the Court of Appeal in England and is taken to mean that the document or documents may well exist, or sorry, may well assist.
Yeah.
So it's not that I have to prove that the documents will assist or that there's a highly probable or a probable chance that they will assist. I simply have to establish that on the material we have before you, they may well assist. And from what I've said so far, I hope it is clear that these documents may well assist the claimant's case. The next criteria is that if they may well assist the claimant's case, is disclosure of the documents sought necessary in order to dispose fairly of the claim? And here we're looking at overriding objective issues such as saving costs, time, inconvenience, prejudice, matters of that kind. And as I've set out, all they're doing is disclosing the documents. We're not trying to prove the truth of the allegations. We are simply trying to show the existence of the allegations. So the face of the document itself. And Judge, you'll obviously have a residual discretion if there are some other matters of extreme sensitivity or confidentiality which might overcome the relevance and the necessity to have these documents disclosed. But I say in this case that doesn't arise. And that flood criteria, as I've set out in paragraph 6.7 of my skeleton, was applied by subsequent cases like Bagshaw and Barrage, which I've set out in the skeleton. You have copies of that as well. So it's well established. And of course, in the case of Beck, one of the observations made by Mr. Justice Linden in the Barrage case, which is in the tab 7 of my authorities, page 511. He says that Beck also effectively makes the point that the greater the importance of the disclosable documents to the issues in the case, the greater the likelihood that they will be ordered to be disclosed, but subject always to any other considerations which are relevant to the application of the overriding objective in the circumstances of the particular case and in particular the principle of proportionality. So when it comes to proportionality, proportionality is exactly what I say. It doesn't cause significant prejudice at all. Now, there are three important points, Judge, I'd like you to take away from the HSBC case that both sides rely upon. And these are contained, the first point is at paragraph 13, subparagraph 1 of that judgment. The second point is contained at subparagraph 13.7 and 13.10. And the third is at paragraph 20. And those three principles that come from that authority, and this is the president of the then president of the Employment Appeal Tribunal, Mr. Justice Underhill, who's now Lord Justice Underhill in the Court of Appeal. And as he explained in the HSBC case, that's my authorities bundle tab 5 at page 486. And at paragraph 13.1, which is at page 486, yes, 486. The starting point that he surveys the applicable principles, and he says, firstly, this, he says, 1, the basic rule is that if evidence is relevant, it is admissible. And if it is irrelevant, it is inadmissible. And he refers to the O'Brien and Chief Constable of South Wales Police Authority, where Lord Bingham of Cornhill said this: any evidence to be admissible must be relevant. Contested trials last long enough as it is without spending time on evidence which is irrelevant and cannot affect the outcome. And I say here, Judge, I say very clearly, this evidence that I'm seeking may well affect the outcome. Relevance, Lord Bingham said, must and can only be judged by reference to the issue which the court, whether judge or jury, is called upon to decide. And so, Judge, you rightly say, what is the nature of the pleaded case? And I've been taking you to examples of that. And as Lord Simon of Glaisdale observed in Crown and Kilbourne, evidence is relevant if it is logically probative or disprobative of some matter which requires proof. Relevant, logically probative or disprobative. Evidence is evidence which makes the matter which requires proof more or less probable. So that's the first point. The basic rule is that if the evidence is relevant, it's admissible. So I say that this evidence is on the face of it relevant or sufficiently relevant to material, and may well assist. So it passes that hurdle. And that's the starting fundamental principle. The second point, which I wish to take you to, is taken from paragraphs 13.7 and 13.10 of the judgment. That's 13.7 is at page 489. And within paragraph 13.7, the EAT president cautions courts in the position that we're faced today against excluding evidence in a discrimination case at a preliminary pre-trial stage. And he says further in that paragraph, where there is genuine room for argument about the admissibility of the evidence, a tribunal at a preliminary hearing may be less well placed to make the necessary assessment. And that's the point I make about, and in support of that, he relies upon Lord Justice Mummery in the Court of Appeal decision of Beezer, Holmes and Stroud. And that is a fundamental principle. Are we confident that if we're excluding these matters, that we are undertaking the exercise from an informed perspective? Now, as I say, with Mr. Khan's grievance, you've got a heavily redacted document. You haven't been supplied with a copy of the unredacted grievance documentation. And in relation to Mr. Odenai and Grace, we haven't got any disclosure whatsoever, because the other side say simply, these complaints are brought by other people, relate to their complaints, not the claimants. And we say that's just not good enough. The second part of the second matter or principle that I wanted you to look at in the HSBC case is taken from subparagraph 10 of paragraph 13. That's at page 490. And there, Mr. Justice Underhill, as then was said, Whether a pre-hearing ruling on admissibility should be made in any particular case will depend on the circumstances of that case. For the reasons identified at 7, that's the previous section I took you to, caution is necessary. As Lord Justice Mummery pointed out in Beezer, Holmes and Stroud, it will not always be possible to make a reliable judgment on the issue of relevance at an interlocutory stage. In the context of discrimination claims, in particular, tribunals will need to bear in mind, though their relevance will depend on the particular case, the observations of Lord Steen and Lord Hope of Craighead in Anyanwu and South Bank Student Union, to the effect that such cases are generally fact-sensitive. And then he refers to prior incidents which are not complained of in their own right, typically because they're out of time, may still be important as shedding light on whether acts complained of occurred or constituted discrimination. Similarly, I say evidence, extraneous evidence outside the causes of action, but evidence of circumstantial discriminatory culture can also shed light. This point was made most clearly by the Court of Appeal in Anya and University of Oxford, notwithstanding that the court had a clear appreciation derived from the judgment of Mr. Justice Mummery in Qureshi and Victoria University of Manchester, which was cited at length in the judgment of Lord Justice Sedley, of the problems to which reliance on a long history of alleged prior incidents could give rise. In our case, we don't have a long history of alleged prior incidents, although there are some. Of the problems to which reliance on a long history could give rise. Now, but each case is different, and caution should not be treated as an excuse for pusillanimity. But each case is, if a judge is satisfied on the facts of a particular case, that the evidence in question will not be of material assistance, and I say, Judge, that on the evidence before you today, we would be surprised if you could say it will not be of material assistance, or because we say might well, in deciding the issues in that case, and that its admission will cause inconvenience, expense, delay, or oppression. And I've said there's no inconvenience, expense, delay, or oppression here. If it is, it's minor. So that justice will be best served by its exclusion. He or she should be prepared to rule accordingly. So you do have a discretion here. We all wholeheartedly accept that. But that must be, we say, a balanced exercise, sensitive to the type of discrimination claim that this is. Now, the third principle takeaway. So the first principle from HSBC I seek to rely upon is the basic rule that if it's relevant, it's admissible. The second is the caution about trying to exclude stuff when you don't quite know exactly what it is and how relevant it's going to be, albeit I say it does look on the face of it that it might well assist. The third point is this, and this is very close to the current position, and this is taken from the HSBC authority at paragraph 20. And this is where Mr. Justice Underhill seeks to explain how the idea of how reliance by claimants upon a background of discriminatory culture or toxic work environment becomes relevant to a race discrimination claim or some other discrimination claim. And it's of particular relevance to the current application. It's the probative value of the so-called background evidence of the discriminatory culture in support of the pleaded causes of action. So at paragraph 20, he says this. This is on page, get there very quickly. It starts at page 493, I believe. Yes, page 493 of your hearing bundle. Mr. Justice Underhill says this, and this is very important to today's application. He says it needs to be appreciated how an allegation of a discriminatory culture fits into the proper legal approach. In a case of direct discrimination, the ultimate question will always be whether the claimant was treated in the way complained of by one or more individuals on the prescribed ground, or, as we will soon be saying, because of a protected characteristic. Where there is a dispute, this is the important sentence, where there is a dispute about whether the particular acts complained of occurred or whether they were done with a discriminatory motivation, proving that, say, sexist behavior or talk was common in the workplace, which is essentially what a discriminatory culture means, may well assist in the determination of that dispute. though it should not be allowed to distract the tribunal's ultimate focus from the particular acts complained of. So what he's saying there is, you have a particular incident of direct race discrimination, and if the claimant wishes to rely upon evidence of a discriminatory culture, that is relevant because it will help to inform a court as to the determination of the direct race discrimination claim. So to take fine tooth-combing pleading points on this point, we say it is unwise. But that's the first proper legal approach, as Lord Justice Underhill uses those words, to how evidence of a discriminatory workplace culture fits into a direct race discrimination claim or a race-related harassment claim, for example, or victimization. But there is a second and quite distinct an additional way in which discriminatory culture is relevant. And he says this: in harassment cases, it may also be relevant in another way, in as much as a discriminatory culture may be an acceptable synonym, though synonyms are best avoided as far as possible, for the statutory language of a hostile, degrading, humiliating, or offensive environment. And as you know, Your Excellency, harassment is a central feature of the claimant's pleaded case. Throughout, he's relying upon race-related harassment and disability-related harassment. And for that case, he's pleading that there is a hostile, degrading, humiliating, or offensive environment that's created for him. So it's central to his harassment claim. In other words, workplace discriminatory culture is central to the harassment claim in a nutshell. So it's clearly relevant. Now, I've referred also to the Dodd case. So those are the three principles I wanted to bring to your attention from the HSBC case. But paragraph 20 is central to today's application. In the Dodd and UK Direct Business Solutions Limited case, that's my tab 8. It's page 532 of my authorities. Sorry, in the application hearing bundle. We see there that again, the emphasis of the court's focus must be on the pleaded case in order to see if the disclosure sought goes to one of the issues in the case. And I've shown you, by reference to Mr. Justice Underhill's guidance at paragraph 20 of HSBC, how discriminatory culture goes to a pleaded case of direct race discrimination, for example, and harassment. And Mr. Justice Auerbach in that Dodd case said this: does not need to show a prima facie case that they will succeed on the issue. All that is needed is that the allegation has been raised, that it's not baseless, and has some reasonable prospect of success. Now, Judge, this, of course, is the first discrimination case under the new laws to be litigated in the DIFC. It's important, it is imperative, we say, that the court has before it all the evidence that is sufficiently relevant or material. In other words, that might well assist one side or the other, where that evidence has been identified, in order that the court is able to make sufficient findings of fact and confidently draw any inferences from those findings of fact. And given the fact-sensitive nature of these discrimination claims, it's important, we say, that at this stage we err on the side of inclusivity rather than excluding relevant or sufficiently relevant evidence. And the other point that is made in by Mr. Justice Underhill in that HSBC case is when he refers to the authorities of Anyanwu and Anya, because he does make the point there in paragraph 10, paragraph 13, subparagraph 10, that those cases emphasize the difficulties that claimants face in these kinds of cases. And we say it is sensible and appropriate at this juncture to err on the side of admissibility, at least until we have had sight of the documents themselves. So with that in mind, let me then deal with the first document, and that's we're seeking the unredacted Khan grievance. The references to I've indicated to you that one area in which we were surprised by the defendants' witness evidence is their blanket denials of a discriminatory culture, or even a perception of a discriminatory culture amongst their staff. They, as far as they say, there is absolutely no discrimination that they've seen or have had any indications of or whatever. And I can give you just the paragraph references, Judge, for present purposes. So, and maybe refer to some things of what they say. So in Steckert number 2, which is in trial bundle at page 229. In fact, let's just take you to that now. So in the trial bundle at page 229.
Yes.
Paragraph 4, second sentence. He says, I do not recognize the claimant's description of the working environment at the bank as being toxic, as described by him at paragraph 9, Lawal 1. And it's worth just going to paragraph 9, Lawal 1. Which is at page 81. You'll see that what the claimant says there is, over the entire tenure of my employment with the bank, unfortunately, I worked in a toxic work environment. The bank condoned ongoing episodes of racism and no action was taken to stop it. It was difficult to stand up against the bank, as this was not the way things were done. And I did not want to ruin my professional career in the financial sector. It was well known that trying to utilize the global whistleblowing policy is futile, as this approach is known to expose employees to retaliation. Over the 8 years of my employment, I encountered many embarrassing, humiliating, and degrading episodes on the grounds of my race. Regrettably, I felt that I need to restrain myself and kept silent in order to preserve my professional career and continue to work in a toxic work environment up until my termination. I set out below examples to illustrate the work culture, and then he goes on to deal with the various examples, such as monkey gestures made towards black employees, including himself, black employees being referred to as Dr. Dre or too exotic and things of that kind. So he evidences the toxic workplace culture, and we know that other suspect the reason to believe that Mr. Odenai, for example, will have complained about these things as well. Mr. Odenai, being the claimant's line manager, will have complained about these same matters in his grievance to the bank. The next point is we see that in Johal 2, this is at page 287. Would you like to be taken?
287?
Yes, 287. It's paragraph 15. He says, I do not recognize the workplace environment as described by the claimant as being toxic, a toxic work environment. It doesn't reflect in any way my own personal experience of the bank. And the point is, whilst these individuals are perfectly capable and understandably able to say that from their perception they haven't witnessed discrimination, they say, the lack of any reference to the fact that the claimant's line manager also brought these discrimination complaints, as well as Mr. Khan, as well as Grace.
Mr. City, what's behind 287? Because I just see blank page for myself from my side.
See a blank page, no?
We are on the disclosure application bundle, yes?
No, we're in the, sorry, Judge, we are in the trial bundle. I should have been clear about that. Trial bundle, page 287.
287. Yes, okay, I see. The working culture at the bank?
Yes, he says that I do not recognize the workplace environment described by the claimant. And then if I can take you to 229 very quickly, just to show you the nature of the defendant's evidence on this.
229?
229.
Yes. Yes.
Here it said that, again, I don't recognize the claimant's description of the working environment. They all use a very standard formulation.
This is Mrs. Sticker to the statement second.
Yes, this is in Steckett number 2. And he also says, I don't accept the claimant's assertion that the bank has a track record of failing to protect the identity of complainants. He says, I do not recognise the claimant's assertion at paragraph 12.1 of Lawal 1 that the culture at the bank means that the staff feel able to make racist comments and that it's okay to discriminate, make fun of colour and make inappropriate discriminatory remarks. But of course, these are the kinds of things that Mr. Khan, Mr. Odenai, Grace complained about as well. And yet these don't feature in the defence, even to qualify them. They try to remain, the defendants, to be clear, try to remain as distant as they can from the complaints brought by Mr. Odenai, the claimant's line manager. As I say, he was also black and of Nigerian ethnic origin. All the race complaints of Mr. Khan, all the race complaints of Grace. Now that's become an issue. It's become an issue given the way in which they've dealt with it, their blanket denials in their statements. And so that underlines, Judge, why, in terms of timing as well, once you saw these statements and the way in which they are seeking to whitewash the situation, saying there aren't, effectively not referring as necessary to the other grievances, in response to at least other people having serious perceptions of a discriminatory culture, we say that is something that needs to be tackled at trial, and it will be tackled at trial by reference to the fact of the allegations brought by these other individuals. We see also, just by way of another example, it's Schmidt 2, at paragraph 4, which is page 211. I think what I'll do is just take some examples, Judge, because I think we don't have the time to go through every reference, but this is to give you an indication of how the defendants are approaching this allegation of discriminatory culture, being silent about these other grievances. Schmidt 2, paragraph 4 on page 211, it says, at no point did I ever feel that I was working in a toxic environment or in a culture in which it was seen to be okay to discriminate, make fun of colour, and make inappropriate discriminatory comments, as the claimant alleges at paragraphs 9 and 12.1. Now, I took you to paragraph 9 of Mr. Lawal's first statement, not paragraph 12.1. Could I just take you to that now as well?
Yes.
That's at page 85. Where he says, I'm aware that there were many racist comments made within the bank. The culture allowed that. It was seen to be okay to discriminate, make fun of colour and make inappropriate discriminatory comments. I was aware of Mr. Odenai being referred to as Dr. Dre, a black rapper, and he deals with that matter. Now, the other interesting point on this issue is that in Schmidt number 2, paragraph 10, that's on page 212.
Yes.
You recall the Dr. Dre matter that was pleaded. Mr. Schmidt says he does recall himself referring to Chris Odenai as Dr. Dre on a couple of occasions, but he can't remember the context. He says, but I cannot remember when I would have said this or who was there when I said it. I may have picked up the name on the trading floor in connection with Chris Odenai, but I cannot recall when this was or who said it. So there is at least an admission that label was used by him towards Mr. Odenai. Now, just on workplace culture, I just want to take you 2 other references. In Johal number 2, which is at page 287.
Yes.
Again, he is saying he's never, he says he doesn't accept the claimant's claim at paragraph 12, and says he himself has not experienced any racism. And then also Cardenet number 2, that's page 248, paragraph 4.
Yes.
and this is the last one to take you to on this subject, pleased to know. But at paragraph 4, I have worked for the bank for approximately 7 years. At no point have I ever felt I was working in a toxic environment in which the bank condones racism and takes no action to stop it, as the claimant alleges in paragraph 9 of Lawal 1. So what's the reality of the situation, Judge? The reality is this. You've got one person, the claimant, saying there's a toxic culture. The trial will hear from all these other defendant witnesses who will deny there's any suggestion of a toxic culture. They've got no suggestion that there is one at all. They're not making any detailed references to these 3 grievances that talk about a toxic culture. And so the court will be not apprised of the full relevant circumstances of the environment which persisted at the time. And that, we say, makes the disclosure of those grievance matters relevant and necessary for the fair disposal of the issues, because otherwise you get this very clean image that the defendant is seeking to portray, that there's absolutely no issue whatsoever. You know, no even indication that there is a group of people at the bank that believe there's an issue. You know, there's not even an indication that we do have that black senior managers who are black and of Nigerian ethnic origin have believe themselves subjectively, at least, that there's a problem. They don't even acknowledge that. And that is highly, highly relevant, particularly when it's the claimant's own line manager and they're of the same race and ethnic origin and complain about similar matters. So you see the point I make, that an argument over relevance is not really going to, we think, get the defendant very far. And an argument on the fair disposal of the matter should not get the defendant very far either. And an argument on proportionality shouldn't get them far because, as I say, it causes little or no prejudice. Judge, would you like me to deal with the nature of the Khan grievance? I dealt with that in my skeleton argument.
Well, to be honest, I have read it in details, and I know what it's about. Yes. If you would skip it, I mean, if you skip the details,
yes, I'll skim it. Let me skim. So basically, Mr. Khan, of course, is an Asian of Pakistani origin. He was a managing director and head of DCM and Islamic finance at the branch, the same branch as the claimant.
Yes.
And in his grievance, he said that the claimant's line manager, Mr. Odenai, was referred to as a gorilla because he was a black man. Further, the discriminatory comments were made against the claimant and other black individuals within the bank, and that showed a toxic, racist work culture within the bank. So that was the nature of his grievance, we understand it. Now, of course, the other side have not adduced any redacted version. What you've got is, if you go to trial bundle, page 310,
yes.
So at 310 to 315, you see Mr. Khan's grievance, 11th of March 2016. And what you see is on 310, almost entirely redacted, whole of 311 redacted, whole of 312 redacted, whole of 313 redacted, whole of 314 redacted, all of 315 redacted. The entire grievance is redacted. Now, we understand why they've at least provided us with the grievance, albeit redacted. It's because, of course, it's pleaded. It's part of Mr. Lawal has made it clear he relies upon it. But the contents of that grievance is what he's relying upon, and they're denying him the opportunity to rely upon its contents. That, we say, is clearly unjust. And what they also disclosed was Mr. Khan's grievance interview notes. That's starts at page 362. If I could ask you to go to that.
Right.
And again, these are the minutes from his grievance meeting with Mr. Khan on the 26th of April 2016. You just skim through the pages from 362 to 367, entirely redacted as to content. And then Mr. Khan sent further particulars of his grievance, I believe, in an information which is at page 371. It's the document of 371 headed grievance information. And 371, if you go flick through to 384, 371 to 384 is almost entirely redacted.
Right.
And can I just take you to one section which was left unredacted at page 374?
To the bottom of page, yes.
And that says, Ralph and Oliver Kern have acted with an unfriendly style in the past, with a well-performing Nigerian-British FIC structurer, Mohammed Lawal, that's the claimant. Lawal told me this. So there's a reference where there is a specific reference to Mr. Lawal, it appears that the defendants have unredacted it. But where there might be other complaints of race discrimination brought by this other non-white senior manager at the DIFC branch, at the same branch as the claimant, the entire complaint is redacted because it said, well, it's not the claimant's complaint. We say that's not the test here. Will the court, Judge, be as may the court, not will, may the court well be assisted? It might well be assisted by understanding and seeing the nature and content of the complaints brought by other senior non-white managers at the same branch. And the answer to that question we say is obviously yes, in a race discrimination claim like this. Your Excellency, whilst I'm on this page, 374, it appears that there is one further clearly relevant document, at least insofar as what's been unredacted. And the other side have been put on notice as to this. The next sentence here reads, I am aware, this is Mr. Khan's grievance. He says, I am aware that in the branch feedback survey held by the bank, such sentiments were raised. So it appears quite clearly that there is a document, a branch or set of documents, branch feedback survey, which records other people raising similar sentiments about discrimination against Mr. Lawal, the claimant, or others who are non-white or black Nigerian ethnic origin. And we have no disclosure of that. We say that that is a further document that needs to be produced by the defendant for the fair disposal of these proceedings. So I just flagged that up as that's going to be that's an additional document request. The branch feedback survey referred to on page 374 of the trial bundle. As I say, even if this was even noticed mid-trial, a judge may well say, well, I'd like to see this document. It's clearly relevant. Such sentiments were raised in that document or documents. Then, Judge, there is a seemingly six-page Khan grievance outcome letter at trial bundle page 388.
Right.
And what you see there is that the first paragraph, the first sentence, first two sentences are unredacted. The rest of the document is completely redacted other than one reference on page 391. But just before we come to page 391, back to the beginning of that outcome document, what that at least shows in the second sentence is that Mr. Khan's, it puts beyond doubt that Mr. Khan's grievance, his two grievance letters of 11 March and 30 May, gave rise to a grievance of race discrimination. Do you see that in the second sentence on page 388?
Yes.
Now, Mr. Khan's grievance is expressly pleaded, as I've taken you to the particulars of claim, and it's expressly relied upon by the claimant. I took you to paragraph 6.1.2 of the application bundle page 18, where he specifically pleads reliance on the Khan grievance.
Mr. Sethi, have you seen in the same document, like at page 391?
Yes.
Toward the end of the page?
Yes.
Where Mr. Khan said, Mr. Lawal told him he have never suffered any disfavorable treatment.
From Ralph Nitzgen.
Yeah. But this is just toward one person.
Yes. It's just about Ralph
cultural
Nitzgen.
situation, isn't it?
No, it's not catch-all. It's not my client saying he's not experienced any discrimination by anybody at the bank. Now, I took you to paragraph 6.1.2 of the particular claim, where he expressly pleads he is relying upon the Khan grievance. That's page 18 of the hearing bundle. And if you had any doubt about that, Judge, if you go to his reply to defense, his pleading at page 194.
Yes.
At paragraph 6.2, he very clearly pleads that as to defense paragraph 28b, the claimant refers to and relies on the contents of the grievance raised by Mr. Khan. It's central to his pleaded case. So forget about him not pleading, or whether there's an argument about not being institutional racism. He's clearly pleaded, he's relying upon that for the purposes of his discrimination claim. Mm-hmm. And he details throughout his particulars the hostile nature of the bank's working environment and the manner in which race-related harassment, discrimination, victimization is tolerated by the bank. That, on any fair reading of the pleadings, is his case. So he clearly pleads and evidences discriminatory culture. He pleads and evidences reliance upon Mr. Khan's grievance and its contents, but he's not allowed to look at it. He's not allowed to see it and rely upon it for no good reason. Now, the claimant has pleaded harassment related to race and racially discriminatory work culture in the POC, judged, for example, at 7.1 and 7.2, and in the reply at paragraph 6 to 9. And Mr. Khan's grievance, we understand, makes reference to the claimant being racially discriminated against by the bank. It's obviously sufficiently relevant or material. Also, Judge, in Lawal 1, and this is important, and in Lawal 1, paragraph 11.1 to 11.2, this is in trial bundle page 83.
Yes.
What we see there in Lawal 1, paragraph 11.1 to 11.2, is that the claimant gives evidence that Najim Khan witnessed incidents of race discrimination in which he was involved, in which the claimant was involved. So the incident between the claimant and Oliver Kern, the COO of the Dubai branch, is the first incident that he says that Mr. Khan was a witness to. And the second is the meeting wherein Nico Gisbert and Roman Schmidt made monkey gestures whilst imitating Mr. Odenai. And the claimant later became aware at this meeting they referred to Mr. Odenai as a gorilla. So you see that in paras 11.1, 11.2. Also in Lawal number 2, paragraph 9.6, on page 138. So 138.
Yes.
The claimant is giving evidence here about the race problem within the bank being systemic and known amongst those who work there. And he says in around 2016, Najim Khan, managing director and head of that department, was in the process of departing the bank. He told me he found the bank to be racist and set out that he had several personal experiences and had witnessed a number of incidents relating to other individuals, including myself and Mr. Odenai. So we want to see what the nature of his grievance was, we say, and that's a perfectly relevant, material, reasonable request in the context of this claim. Now, Mr. Lawal, the claimant, was named as a witness for Mr. Khan's grievance and the claimant is well aware that Mr. Khan filed this discrimination grievance in relation to race. That's Lawal 1, paragraph 11.4 on page 84. So page 84, 11.4. And on page 85 in the trial bundle, at paragraph 11.7 of Lawal 1, that states that Mr. Khan reported the incident between the claimant and Mr. Kern, but this was not mentioned by Karen Jones when she asked questions of the claimant as part of the investigation into Mr. Khan's grievance. So the point briefly being put by all these references, Your Excellency, is that Mr. Lawal's pleaded case, his evidence case, this is a key feature of it. Now, the defendants are in possession and in control of the unredacted documents. The fact that it relates to Mr. Khan's grievance, not the claimant's grievance, doesn't trump the admissibility of the document. It is sufficiently material and relevant. If there are some particular compelling, important confidentiality reasons why the court should not see and the parties should not see the unredacted document, if there are some aspects that still need to be redacted, well, that they can be justified. But whole-scale redaction of Mr. Khan's race discrimination complaint is wholly unjustified. So just to close on this first document, this first important document, the claimant relies upon it for his pleaded case. He relies upon it for his evidence case. Mr. Khan's grievance included complaints of race discrimination suffered by the claimant and by the claimant's line manager. But they've only disclosed one aspect of it, which makes a reference to the claimant in unredacted form. The documents we say are clearly might well be probative or sufficiently probative of the acts of discrimination alleged by the claimant in the case sense that it is of background evidence of a racist workplace culture in which he had to operate. So it might well assist in the drawing of inferences as to whether the motivation behind certain things towards the claimant was racially motivated. Background evidence of a racist workplace culture, as we know from the HSBC case at paragraph 20, is not just relevant to a direct race discrimination claim, but where you're arguing about harassment, it's directly relevant because you're showing an intimidating, degrading, hostile, offensive environment. And production of the documents, Judge, is not said to be highly prejudicial or cause, quote, inconvenience, expense, delay, or oppression. It will not seriously affect the estimate of the trial, and there's no material prejudice to the defendants in just disclosing the documents themselves. All that is being adduced are very similar, very serious race discrimination complaints made by other Black Nigerian bank senior employees linked to the claimant and the branch, as evidence of an environment in which other Black Nigerian senior employees considered it necessary to lodge formal grievances similar to that raised by the claimant. And so production of those documents is in the interest of justice, and it's in accordance with the overriding objective. Now, Judge, you will have read that. That's dealing with Mr. Khan. You'll have read similar submissions in relation to Mr. Odenai, the claimant's line manager, and Grace. Forgive me if I pronounce her surname wrongly, but earlier. But you'll have seen a similar submission in relation to that. I can go through the detail of that as well, but you have that.
I do have, yes.
Contained within the. There are. Yes. I think the point was made by my learned friend that Mr. Khan is not being called by the claimant to give evidence. You'll see from the pleaded case and the evidence here that the defendant bank is in the practice of entering into settlement agreements or exit agreements with individuals, a term of which is effectively a gagging order. And we believe that Mr. Khan is subject to such restriction, which is why he's not giving evidence. But that is important to say. Now, Judge, in relation to Mr. Odenai, I've made the point. Claimant's line manager, same branch, same racist claimant, makes similar complaints, and there is overlap of complaints between what the claimant complains about and what Mr. Odenai complains about. The Dr. Dre comments are against Mr. Odenai, for example, and the gorilla and monkey gestures, for example, against both. There's clear overlap. There's clear direct relevance. We say that there is every reason why Mr. Odenai's grievance should also be disclosed for completeness. I'm aware of the time, but do you wish me to go through my submissions in relation to Mr. Odenai?
I mean, not really. As I said before, I'm aware of it. I have read it in details, and I think it's shared with the first Mr. Khan document circumstances and relevance. So I think it will fall in a similar test as well. It
does, and I think I'd be largely repeating myself, but you have my written skeleton in that regard. And remember that those two also were complaints of race discrimination. I think the key point I make is the reliance upon HSBC paragraph 20 in the two respects in which workplace discriminatory culture is relevant background evidence to pleaded discrimination claims, both for discrimination and for harassment, which I've taken from paragraph 20 of HSBC. Yeah, so I do say it's in accordance with the overriding objective for both Mr. Odenai and Grace's grievances to be the subject of a document production order in the terms that we seek. I haven't said much about Grace Atuweogu, but her grievance documents are clearly sufficiently relevant or material. Lawal 1, paragraph 15, for example, this is trial bundle page 87, states that the claimant mentioned that his black colleague, Derek Anim, informed him that their black colleague, Grace Atuweogu, raised a grievance against the bank as she was called racial slurs, including nigger, and that Derek Anim was a witness. So we have clear, reasonable basis to believe that she was bringing similar complaints of racial slurs as the claimant did. And the other point about Grace is that both Grace and the claimant ultimately reported to Nico Giesbert, the same person, in relation to their work, and they often work together. So there's clear linkage.
I see.
Judge, if I move on to the document production request number 4, because the first 3 are the grievances.
Yeah, the Singapore matter, yeah.
No, this is the claimant's own performance appraisals. Singapore matter is number 5.
Yes.
So here the point, I hope, is relatively simple. The claimant simply wants to see his own previous annual performance appraisals. These are documents to which he's perfectly entitled upon request. They should be giving it to him without a fight. These are his documents. He's got the right to see them. He's not after the performance appraisals of anybody else. It's him. Why are they being so coy about it? In a nutshell, what our position is that every year the claimant was a high-performing, highly appraised senior executive of the bank at the branch. And indeed, in Q4 of 2022, he was doing so well that he was offered 2, not 1, 2 promotional job opportunities because he was considered that good. But he presented, in the meantime, a race discrimination grievance and a whistleblowing complaint. And thereafter, he is severely downgraded in his next performance appraisal, upon which the defendant says it relies in coming to the decision about his bonus for that year. So why might it well assist the claimant to see the previous performance appraisals? Well, it will show how highly rated the claimant was. It'll show the dramatic contrast between consistent previous high scoring years and then this dramatic falling off in performance after he presents his race discrimination grievance and his victim whistleblowing complaint. The court needs to see this. It's obviously relevant. But what one worries about is not only is it so obviously relevant, why are they putting up such a fight to give the claimant that which he should be perfectly well entitled to at the drop of a hat? Just as a former employee saying, I'd like my own performance appraisals, please. He's entitled to it as by way of a data access request. We all know this. Why are the other side putting up a wholly unreasonable fight and a fanciful basis to object to this? In any claim where 1 year's bonus award is an issue based on that year's performance appraisal, it might well assist and be sufficiently relevant to see what the previous year's appraisal was and the year before that. And if it was consistently high in all the years before that, that would be of high relevance. And the court would want to understand what changed. The court will be asking itself, what changed? And that is what's central to this. So that's the short point, and I think the most powerful way to present it, Your Excellency, because I think that encapsulates why we need to see the previous performance appraisals. Again, push of a button on the HR file computer should be able to send that across. No prejudice whatsoever, no oppression, no delay, has no impact on trial. There should be cooperation between the parties on things of this kind, not obfuscation. And it's troubling that we are having to push at this level on such a matter. But
are we talking about discretionary bonus in here, or mandatory bonus?
Well, as I understand it, it is based on two aspects: two ratings, as it were, and then a percentage is applied.
No, my question, is it at the discretion of the company that they might not even pay him a bonus at all?
Yeah, so in this case, it's not a no bonus issue, it's a severely reduced bonus, as I understand it.
Oh, but the nature of the bonus, is it at the complete discretion of the company, or it is
No, I don't think
it is part of his remuneration, but based on certain assessment that the company should do to reach certain calculation?
It's the latter.
I see.
It's the performance appraisal that, as I understand it, I'll be correct if I'm wrong, primarily determines the award of bonus, the level of bonus award.
I see one.
So, Judge, you can see the relevance of it, and I hope I haven't put the matter flippantly. We wonder why something of such simplicity and little effort in disclosure, why such a fight, as it were, is being made in relation to it. I've set out in detail at paragraph section 9 of my skeleton the necessity for the claimant's own performance appraisals, and we say the submission is compelling. I think the next point is the Singapore applications matter. Document production request number 5. Actually, Judge, there's one point on the performance appraisals, for example. I note that at trial bundle page 785,
right,
the defendant has disclosed a summary of appraisal scores for the immediately previous year. You see that in the penultimate column headed appraisal.
Yes.
But they have not disclosed the underlying document evidencing that or supporting those scores, those appraisal scores for that year. So even the defendants have provided a summary of the 2020, I think this is, bonus payment table and the score, but without providing the underlying performance appraisal itself of the claimant. And we're not after the other people's performance appraisals, it's the claimants.
Yeah, is this about a single year, isn't it? It's not about.
Yes, this is about a single year, I believe. This is a summary of the 2020 bonus payment table. In other words, the year prior to 2021.
Yes, I see.
Yes. So, Judge, if I'm just going to see if I need to take you to another document. Yes, the performance appraisal that was disclosed is at page 1196. So, Judge, you can see what the document looks like.
Yeah, I think, I mean, is that correct from my understanding of the particular of a claim that the bonus is not just discrimination issue, but it's I think employment remuneration issues that's claimed
Yes.
by the claimant.
Yes.
So he asking for this to be corrected, to be paid at least, I think 70% instead of 42. Something
Yes.
like that, I guess, yeah.
And it's also victimization.
And victimization, I see.
Yes. A number of the
limbs, yeah.
Yes, a number of the detriments arise under a number of causes of action.
Right.
If in the interest of time, I move on to the document request number 5, which is
Please.
the Sitlani applications.
Please.
Hopefully I can be brief here. We request production of the applications completed by Mr. Deep Sitlani for any of the structured solutions roles that he applied for in Singapore. In this case, Judge, as you would have seen, that the claimant has raised serious concerns in his pleadings in relation to the hiring process at the bank breaching regulatory laws. And Mr. Sitlani's application will illustrate that the bank failed to adhere to regulatory laws, as Mr. Sitlani was ultimately offered a higher wage than the wage band advertised publicly by the bank to potential external applicants, thereby leaving external applicants and Singaporean candidates at a disadvantage. So we say it was an unlawful process. And the same thing happened to the claimant. And the defendant says that Mr. Sitlani applied for the role of head of structured solutions sales, which the claimant believes is untrue. And the claimant believes he applied for the global head of structured solutions, as the defense put forward by the defendant claimed only 2 individuals applied for the role, the claim to Mr. Odenai. Now, the claimant has not yet requested this document by way of a request, and we put our hands up to that. It's an oversight, but we are where we are, and we are here now. Is it in the interest of justice? Is the overriding objective best served in disclosing those few documents? And we say yes, for the same reasons as previously. There's no prejudice, no expense, no further witnesses required. It's simply to see what the documents say. Now, the documents are relevant or sufficiently relevant or material to the issues in this case for these reasons. If you go to trial bundle page 106,
(106)?
106, yes.
All right.
We see there that in paragraph 67.5 Roman numeral 4 of Lawal 1, the claimant states that Inga Johal falsely alleged that cost/increased expense adjustments such as housing and schooling allowance were not available in the relocation package, but provided such benefits to Yavuz Makun and Sara Sankari. Then at page 135 of the trial bundle, paragraph 8.18 of Lawal 2, it's page 135. The claimant states that Vimal Tezu and Avinash Bathija received higher salaries than the benchmark salaries for L4 executives in Singapore, and the claimant finds it hard to believe, we say that Difc Sitlani received a lower salary in Singapore than in Dubai. And we see that also at page 167 of Lawal 2, at paragraph 10.56.4, so that's page 167, the claimant states that the defendant must provide evidence that Difc Sitlani and others who relocated to Singapore did not receive additional incentives, awards, allowances, or inducements for relocating to Singapore. Now, in the defendant's witness statements at Cardani 1, that's page 241. They do try to address the point. So it is in issue, Judge, between the parties. At Cardani 1, paragraph 35, it said, one other employee, Difc Sitlani, also received an offer of a new role in Singapore, head of structured solution sales, which was on a lower salary than the salary he received in Dubai for the same reasons as the claimant. And our claim is that Mr. Sitlani received a higher salary than advertised. So the point here is that it's denied by the defendant that the claimant did not claim that, the claimant denies that he didn't claim that the defendants failed to adhere to the regulatory laws, because if you look at POC paragraph 7.6, it's clearly pleaded that the bank had breached Singapore's Ministry of Manpower guidelines. Mr. Sitlani's applications to the Bank Singapore roles are relevant in determining whether the bank breached such guidelines. Mr. Tezu's application has been disclosed, but there is a refusal to disclose Mr. Sitlani's application. One wonders why there is a discrepancy. They've disclosed Mr. Tezu's, not Mr. Sitlani's. There's no good reason, we say, to withhold production, Judge, in relation to this matter. It clearly is relevant to have pleaded an evidence matter in dispute between the parties and might well assist the claimant. I only need to go that far. It might well assist the claimant in relation to his cause of action in relation to the Singapore applications.
Is it in the claimant case that Mr. Sitlani receives the offer in a higher, let's say a hidden higher salary, that because of discrimination, race basis discrimination? Is that the case, or why he was in less favorable situation getting that position or salary? Yeah.
No, this is simply in relation to being in breach of Singapore regulations.
The company in breach of regulation?
Yes.
And what's that to do with the claimant? Sorry.
Because the claimant was similarly offered a Singaporean role in breach of the Ministry of Manpower guidelines. It's the hiring process that the claimant pleads breaches of law in the hiring process for the relocation, and that's where this becomes relevant. So it's not a comparison of race between him and Mr. Sitlani.
Please,
it's also in his grievance.
I'm having difficulties really here and understanding what is the cause and what kind of case you're trying to show based on the documents you are acquiring.
Mm-hmm.
I mean, what you trying to demonstrate by acquiring such evidence or documents to the trial, like whether the claimant have received less favorable position because of the breach, or that Mr. Sitlani got the offer based on discrimination or race discrimination, or I'm having difficulty understanding this.
No, it's if we park the discrimination issue for a moment, now we move away from discrimination. But both him and Mr. Sitlani were offered Singapore relocation offers in breach of Singapore's Ministry of Manpower guidelines. I'll be corrected if I'm in any way misrepresenting that by those instructing me, but it's a fully pleaded matter.
Are you saying he received less than what he's supposed to get?
No, he was given an offer which is unlawful under Singapore regulations.
What damages he's seeking based on this?
Because he would not have been it's to his detriment that he's being made an offer which is not lawful, not valid, as was Mr. Silani. Both of them were receiving offers to their detriment, which were unlawful. I believe that is the. I'm trying to be pithy here, but I think that is the essence of it.
I see.
So, Your Excellency, I'm just going to see if I need to address you on anything else before.
Please, yeah.
I'm told it also helps to explain why the claimant did not take up the Singapore opportunity in the evidence. I'm just going to take instructions on one point, Judge. Bear with me just for a brief moment.
Please.
Thank you, Judge.
Yes.
I'm grateful.
Well, in that case, Ms. Sethi, we shall break now, Ms. Masfand, and we'll be back in about 40 minutes time from now. Is that okay with you, Mr. Masfeld? Yeah, 40 minutes from now.
Indeed, Your Excellency, yes. So I make it, well, it's 5 to 10 London time, so 10:35 UK time for Mr. Sethi and I, and whatever time it is where you are.
2:30 Dubai time, yes, exactly. And I'll see you then in your turn. Thank you.
Thank you.
Thank you.
Good afternoon.
Good afternoon.
Good afternoon,
Ms.
Your Excellency.
Masfeld? Yes.
Thank you. Your Excellency, I'd like to start with agreeing with a few points of approach by Mr. Sethi, although obviously we disagree on how the approach applies. It'd be helpful, I think, to clear out where we agree. The first point is, and Mr. Sethi has set out a number of the cases from the English courts and tribunals in relation to disclosure and admissibility of evidence. And I agree with him that the approach of the English courts is illustrative and helpful in my submission in the approach to be taken in this court. The second is that I agree with 2 points that he emphasizes in his skeleton arguments. One is the test for production, or as disclosure, as an English court would say, is whether the production of the documents is necessary in order to dispose fairly of the claim. And second, that the question of necessity and the question of sufficient relevance, which is expressly referred to in this court's rules, has to be assessed against what the pleaded case actually is, what the allegations are that the court has to determine. And you've heard, I'll develop this point further in a moment. You've heard a number of references from Mr. Sethi as to how he says the documents that are sought are relevant. I just flagged this point for consideration as I go through my submissions. Quite a lot of what Mr. Sethi relies on is what's in Mr. Lawal's witness statements. That is not the right place to start from. The right place to start from, in this case, is the particulars of claim and the reply, the repleted case, and of course the agreed list of issues that has set out the roadmap for what this case is about from an early stage. The second point that I wanted to make, where I agree with Mr. Sethi, is that the question of the timing of the application, I agree with him, is not a threshold question. In other words, one can't simply decide this application on the basis of it being made late. I say the timing is important in this case, but I don't take what Mr. Sethi characterizes as a technical point. It's a point of real substance, because one has to see this application in the context of when it was made, the reasons why it wasn't made earlier, and most importantly, what the documents are that are sought and the impact that they're going to have on the proper conduct of this trial, which is starting in less than 2 weeks' time. And Your Excellency was absolutely right to raise that question with Mr. Sethi about what's going to happen with these documents and how we're going to proceed at the beginning of his submissions. What we say is, first, there is no good reason why these documents are being sought at this time. They could have been sought a lot earlier. Second, they are being sought at a time that is going to be extremely difficult for us and the court to deal with them. And I don't say that, and I agree with Mr. Sethi to this extent, he's not asking for document searches to be conducted as one finds in production for us to trawl through vast number of emails and look for documents. I accept that. So, however, I don't accept that we can just push a button and provide the documents today or tomorrow. It's going to take some time to collate them. But I have to accept that the documents that he seeks can be provided before trial. I can't tell you exactly how quickly before trial they can be provided. But the real problem in this case is what the parties, and in particular what the court, is going to do with those documents if they're disclosed, and what it's going to make of them. Because the situation is this. This is a wide-ranging claim that raises a whole series of different allegations of different types of discrimination, whistleblowing, breach of contract, unlawful deduction from wages. It's a wide variety of issues that are in it. It is going to start at trial in less than 2 weeks' time, and as Your Excellency will know from when we appeared at the PTR, has been carefully case managed to fit within that time. With respect to the claimant and his legal representatives, the claim is somewhat diffuse and difficult to follow in places, but the court has to grapple with that. There is a real danger of this case spiraling out of control. The reason I say that is this, that first, look at the way in which the case has developed, and I'll make these points good in a moment. There's a pleaded case and a list of issues that was agreed. Mr. Lawal's first witness statement, Lawal 1, which is his first trial witness statement, runs to 32 pages. It deals with the pleaded issues. It deals with a number of allegations that do not appear in the pleadings. So there's already a question the court will have to grapple with as to how much to get into evidence that he gives that isn't in his pleaded case. His reply witness statement, which was signed on the 5th of December, is 80 pages long. So almost more than twice the length of his main statement. There's quite a bit of repetition. There's quite a bit of overlap with his first statement, but there are also new matters raised that are not contained in the first statement. So already at trial, the court's going to have to grapple with how it manages within the allocated time to get through all of that evidence and deal with it. What the claimant now seeks is 5 categories of documents after exchange of trial witness statements and reply witness statements. So whatever the claimant wants to make of them, nobody's really properly dealing with those documents in their witness statements because they haven't been disclosed. Inevitably, it will take time to deal with whatever comes out of those documents. And we say we are prejudiced in the ability to deal with them, not only because our witnesses haven't dealt with them in their statements, but second, they may well relate to, and clearly do relate in some instances, to other incidents outside the pleaded case that we can't have anticipated we needed to be dealing with, and that we don't have witnesses to deal with. And Your Excellency, this brings me to a broad point about what the claimant tells you today it wants to do with these documents, or perhaps I should say more importantly, what it's going to be inviting the court to do with the documents. And I'll go through with them each by class. I want to deal in more detail, but I want to take the 3 sets of grievance documents, so the Khan grievance, the Adunye grievance and the Atuwogu grievance, and just make a preliminary observation, first of all, about what's being said about those 3 groups of documents. Now, I have to say I was surprised by Mr. Setty's submission that he says the claimant doesn't rely on those grievance documents for the truth of the allegations that are made within them. I complained that that's clearly what they were trying to do in my skeleton argument. He says I've misunderstood. And if I have, well, I'm afraid I still misunderstand the position now, because I simply do not understand, in the light of the lengthy submissions you've had from Mr. Setty this morning, how it can be said that the claimant does not want to rely upon the grievance documents as evidence of the truth of the matters that are raised in them. He says they don't, but in substance, what he says clearly indicates that they do. The grievances will raise a number of factual allegations that are raised by the 3 individuals that made the grievance about their treatment. I should stress at this point, as perhaps as a side note, that insofar as Mr. Khan, in his grievance, talks about Mr. Lawal, has any evidence about the treatment of Mr. Lawal, we have disclosed those passages, and Mr. Setty's taken you to them. And I'm confident that all of the material about Mr. Lawal from the Khan grievance has been disclosed. And indeed, Mr. Setty has not put his submissions on the basis that he doesn't think that the bank's lawyers have done a proper job in disclosing the Lawal material from that grievance, or that he's not satisfied that has been. So what the claimant wants to see is material that's not about him, but is about others. And the question for the court then will be, well, how does that material in any of those 3 grievances assist the court in deciding the allegations that the claimant makes about the way in which he was treated? Mr. Setty says, well, those other grievances are evidence of circumstantial evidence of a discriminatory culture within the bank. But that's an argument that pulls itself up by its own bootstraps. The contents of those grievances are only evidence of the culture if what the grievances say are true. If the grievances make allegations which are false, either deliberately so or mistakenly so by the makers of the grievance, then they don't assist the court in determining whether there was a discriminatory culture or not. They can't do. False allegations, unproven allegations, can't prove that there was a particular culture. Yet repeatedly, Mr. Setty tries to say, well, we're not looking to prove the facts of what's said, but we are relying on what's said as circumstantial evidence of to support our discrimination case. And that, with respect to him, is a completely incoherent position to make. So were these documents to be disclosed, what will the claimant be asking you to make of them? What evidential weight should be attached to them? And how will Mr. Setty do that without inviting the court to address the merits of those allegations? I simply don't understand that. And we can test it by, if you'll forgive me, Your Excellency, for what one might describe as a small thought experiment or hypothetical. If Mr. Setty is not asking the court to treat the allegations made in the grievances as true, can we proceed on the basis that all of those grievance allegations are false? That would be consistent with his position that he's not asking you to determine the truth of them. And if you were to ask him that question, do we proceed on the basis that all the allegations are false? I can see the smile on his face. He's going to say, no, of course we shouldn't proceed on that basis. So what is he asking us to do with them? But that's as good a starting point as any, because the bank investigated those grievances and it dismissed them. In Mr. Khan's cases, and you know this from Mr. Clement's witness statement, Mr. Khan brought a claim that he withdrew and paid a contribution to the bank's costs. Mr. Adunye brought a claim that was fiercely contested by the bank in this court that was settled shortly before trial. So there is no basis upon which to find that there is merit in those allegations, yet inevitably the claimant's position is going to involve the court in having to weigh the merits of it. And it's perhaps just worth going, that's not just a question of what Mr. Sethi tells you in his submission about the value of this evidence circumstantially. We can see it from the way in which the pleadings put and the allegations made. Sorry, this application is made on the basis of its evidence. Mr. Sethi drew your attention to a paragraph in the reply to defence filed by his client, and it's an application bundle at page 194, paragraph 6.2, where this is in the section replying to the defence on harassment related to race and or disability. 6.1 says, to the extent there are conflicts pertaining to factual matters between the parties, they're to be determined at trial. Well, that's true, but it depends, of course, what those factual matters are. 6.2, excuse me, forgive me, Your Excellency,
Please.
Notwithstanding the generality of the foregoing, as to paragraph 28b, that's 28b of the defence, we'll go back to that in a second, the claimant refers to and relies on the contents of the grievance raised by Mr. Khan, which contents will be well known to the defendants and form part of the documentation which they hold. So I don't understand how, on the one hand, the claimant's position is he's relying on the contents of the grievance, but on the other hand, Mr. Sethi can say, well, these documents won't cause any further inquiry or disruption to the trial because we're not taking a position that the contents of it are true. But further, if we look at Ms. Moyo's witness statements that are in support of this application, the first witness statement starts at 236. And the Naj Khan grievance starts at paragraph 6.
Yes.
The claimant is aware that other black individuals have been referred to as gorilla by individuals within the bank. I should pause, that's not a pleaded allegation, it's one that's in the Lawal witness statement. But look at how it's framed. That's framed as a proposition of fact. The claimant wants the Khan grievance because, one, it thinks it can point to a paragraph in which that allegation is made, and two, that it's going to say, well, that's true. Mr. Khan said it, and it was true. In response to that, Mr. Clement's witness statement, which starts at 244, deals with the Khan grievance at paragraph 16 onwards at page 247. And at paragraph 23, Mr. Clements describes the point that I've already made to you about the progress of the Khan grievance and his complaint in London, and says the redacted portions solely contain unproven allegations against other individuals at Commerzbank that have no relevance to the claim brought by the claimant, in respect of which a claim was withdrawn. Ms. Moyo's second witness statement starts at 256. At paragraph 10, she says the Khan grievance is relevant to demonstrating a hostile, racist, victimizing work environment as pleaded by the claimant that black employees of the bank had to endure. Pausing there, Your Excellency, insofar as the Khan grievance relates to Mr. Lawal, those portions have been disclosed. Insofar as Khan talks about his own treatment, there have been a number of references earlier on in the day to a number of Nigerian or black senior managers complaining of discrimination. Mr. Khan, as Mr. Sethi later said, is a Pakistani gentleman, not a black or Nigerian gentleman. And part of the claimant's complaint, insofar as he complains about matters at the time of his dismissal and relocation, is a comparison of his treatment with Indian and Pakistani members of staff. So the treatment of Mr. Khan, even were it true and provable, doesn't go to the point that's made there. But then at 11, Ms. Moyo makes some points about common practice for claimants to withdraw claims once settlements are entered into. It's not suggested that Mr. Khan's claim against the bank was withdrawn for lack of merit or any other reason. And she goes on to say that the circumstances of the compromise don't suggest that they lack merit. Well, I mean, we say, in fact, if you withdraw a claim and pay a contribution to cost, that does have some reflection on merit. But I want to make 2 points from that. First, it is clear that the claimant's position is that the merit of the Khan grievance, i.e. the truth of its allegations, is what it wants to rely on. Second, in the circumstances in which we're in, this was a claim that was brought and compromised back in 2016, that no party is in a position to deal with now, 2 weeks out ahead of a trial, and nor should the court get involved in dealing with that at this distance out from trial. Because what would happen if these documents were disclosed, and it's true of the Khan grievance, it's true of the other grievances, is that the court risks becoming distracted by effectively a trial within a trial of allegations brought by another person on the basis, one, to ascertain whether or not the facts are true, and two, to determine whether those facts shed any light or add any weight to the claims that are actually brought by the claimant in the case. And that's an exercise that the court should never embark upon in this case, but certainly shouldn't embark upon at this distance and time out from trial. And there is a real danger, well acknowledged by the courts in England, of discrimination cases losing focus and becoming distracted by satellite issues. And if Mr. Sethi is going to say, well, the significance, the relevance of this evidence is that the grievance was brought, then I ask, how is that relevant? The mere fact of the bringing of an allegation doesn't prove that it's true. And if it's not true, it's not probative of anything. The danger is, if the court has evidence of these other grievances, of matters pertaining to not directly relating to the claimant and or relating to treatment of others, there's a risk of the court saying, well, there's no smoke without fire, there are grievances made. It would be wholly wrong, in my submission, for the court to proceed on the basis, because some other people complained, then the allegations have force in them. The way in which I agree with Mr. Sethi that discrimination cases are fact sensitive and that they need careful consideration of the evidence, and that often the court is being asked to draw inferences where there isn't direct evidence. But at the same time, fact sensitive turns on a question of what the facts are and what the relevant facts are, not immaterial facts. And second, the English courts have been consistently clear in the focus on identifying and determining what the pleaded issues are in the case that need to be resolved. That brings me to a more general point, if I may, Your Excellency, about what's said about the institutional culture, the toxic workplace culture that's alleged. And there are two broad points to make about this. The first is that expression, toxic workplace culture, appears in the Lawal first trial witness statements. There's not a pleaded case of a broad toxic work culture. The second point is that to say that a particular workplace has a toxic culture is easy to allege in general terms, very difficult for the court to resolve without determining whether that culture exists by finding particular facts about particular instances. So it's unsatisfactory for a claimant or a witness simply to allege, well, there was a toxic workplace culture. What does that derive from? What are the instances through which it manifests itself? The court needs to have in front of it clearly identified alleged facts that amount to the creation of that workplace culture, and then determine whether that culture exists, and then determine whether decisions about a claimant that are alleged to be unlawful were made on discriminatory grounds because of that culture. What one can't do is plaster over gaps in the facts one alleges by some vague allegation of a toxic workplace culture. One needs to be, a court need be cautious in relation to that. And so,
Mr. Mansfield, if you
yes,
allow me to stop you here, I mean,
of course.
Usually if someone, lodge a grievance into other bank or any institution, that must be followed by an investigation.
Yes.
Through the investigation, I'm sure there are a lot of things can be either proved. The investigation could lead to a conclusion. You know what I mean? Sometimes they could lead sometimes to an action as well. So for now, as what Mr. Sethi has said, we didn't know really for example, a grievance is completely redacted. We don't know how that have been dealt with by the bank, whether that investigated in which way, with the concerned employees, who are accused for doing the racism or discrimination, what have they said exactly about it? What companies' action have been held? They might be, the document, as Sethi said, it might reveal and more information.
Well,
yeah.
Information, with respect, Your Excellency, information is an interesting word to use. It
well, he might use fact, maybe.
Well, with respect, that's where I would differ from you. The grievance documents themselves will not reveal facts. They'll reveal the allegations that were made, and I accept they'll reveal what particular witnesses said in the course of that investigation, but the court would have to evaluate what the facts were in relation to those matters. My understanding is that each of these three grievances was dismissed. Mr. Sethi, if I read the flow of his clients' submissions and some of what he says in his witness statements, will want to say, well, if they were dismissed, the bank was wrong and they didn't carry out the grievance properly. One of the things that Mr. Lawal complains about in one of his witness statements is that when he was asked questions in the Khan grievance, they were asked in a particular way that he says didn't give him the opportunity to address things that he wanted to address. So as soon as one gets into evaluating the material in the grievance, one can see that there's a lengthy case to be had on itself about the way in which the grievance was conducted and whether the bank went about it properly, whether it was in a position to reach the right conclusions. Unless Mr. Setty's telling me all of those things are irrelevant, then, well, it looks like he is telling me all of those things are irrelevant. Well, in which case, it's difficult to see how the mere fact of the grievance and the points being raised assists the court in any way.
How about going to square? How about to go to square one? I mean, if Mr. Setty could say, where I have 3 different employees as raising a grievance related to hostile or toxic or let's say racism environment, is something to support the claimant to claim for racism, discrimination, and other things.
Well, that would be an incorrect submission to make. The mere fact that 3 complainants complain of things, even if they were the same thing, doesn't demonstrate that it's true, unless you're saying, and I know Mr. Setty wouldn't say this, unless one's saying, well, there's no smoke without fire. 3 people complained about it, so there must be some truth in it. That would be a dangerous route to go down. One would have to treat the truth of the allegations first as matters that need to be proved, and second, matters that, if they're going to be proved, would require proper consideration at trial on the evidence. So in my submission, Mr. Setty can't have it both ways. He can't say that he's not relying on these allegations for their truth, so there's no disruption to the trial, and at the same time seek to attach probative weight to them without proper investigation of them.
Judge, can I just interject just to say that any court in a case of this kind would be highly interested as relevant evidence that other people in the same department or the same branch made similar claims against similar people or the same people at around the same time. That's highly probative evidence. Now, no one's asking the judge or at trial to determine the truth and investigate all of those other grievances. Not at all, not at all. But the nature and substance of the allegations contained in those grievances, where there is overlap with the claimant's case, is highly relevant. So it's not the fact they brought a grievance, it's what their grievance was about. And it's not about whether the grievance was true in the end and what the details were, although the employer's outcome reports will be highly relevant, of course. But it's the nature and
then
content.
you will go to square one again, as Ms. Masso said. Who said this is true? What if we said, oh, it's completely unfounded allegation, and the court cannot rely on it?
The point is, it's not whether the court's not being invited to decide the other grievances, the truth of the other grievances at all. What the court is being invited to assess is that in circumstances where all the defendant witnesses say, we see no discrimination, we hear no discrimination, and yet very senior managers very close to the claimant are raising very similar things, overlapping with what the claimant complains about. Why is that not highly relevant to understanding the context in which the claimant's claim is brought? Why is that not relevant? The fact and nature of the allegations, not and the way and the outcomes, but when no one's asking for an investigation by the court into those other allegations, but the nature and content of those allegations is highly relevant.
And is that helping the claimant and assessing or weighting the credibility of the defendant witnesses too?
Yes. Well, because all the defendant witnesses say, no, we're a clean organization. But if you've got these very senior managers who are Black Nigerian making very similar overlapping complaints about the same people and about the same things, that is probative evidence. But Judge, I don't want to, I've interrupted. I apologize. I only wanted to do so in order just to narrow down the issue between the parties. It's not the fact of them having made complaints, it's the nature and content of the complaints. And it's not the truth of the complaints, but of course the outcome findings and conclusions by the employer will be relevant.
Well, Your Excellency, and I'm not inviting Mr. Setty to interrupt again on this point, but it's helpful in a sense that he did. I simply do not understand how Mr. Sethi can say, without ascertaining the truth of the allegations, the nature of the allegations is probative of the matter contained in them. That is an impossible circle to swear, in my submission.
It is not. It happens in many cases. Judge, if 10 other people are complaining about exactly the same thing that the claimant complains about the same other manager, albeit they settled their claims when they brought them to the DIFC Court of First Instance, their internal grievances are highly relevant. And it's not an issue about no smoke without fire. It's the fact that the court needs to be aware, it's necessary for the fair disposal of the claimant's case for the court to be aware that certain other senior black people have brought, it might be near identical complaints. And if you, in relation to Mr. Odenai, we know the grievance manager, Mr. Houghton, it's trial bundle page 110, paragraph 1, he says that the grievance filed by Mohammed Lawal that has a lot of overlap with the grievance by Chris Odenai. That's what he says, page 110 of the trial bundle at paragraph 1. It has a lot of overlap. This is the grievance manager, the defendant's own grievance manager, who looked into Mr. Odenai's grievances of race discrimination, says it has a lot, quote, a lot of overlap with the grievance.
Thank you, Mr. Sethi. Yeah, we'll go back to Mr. Mansfield.
And again, Your Excellency, I'm not inviting Mr. Sethi to interrupt again, but a question that arises is what use Mr. Sethi is going to make of these documents when the bank's witnesses give evidence. Will he be, a question for later that you may,
okay, well, I'll answer that later.
wish to answer him, will he be putting to any of the bank's witnesses that the content of any of these other grievances were true or not? Either he is, in which case he is very much relying on these documents for the truth of their contents, or he is not, in which case the court will not have had the opportunity to see what the defendant's witnesses have to say about any of these issues, because Mr. Sethi will have determined that what they have to say about them is not relevant to the case. Either of those outcomes,
I think it would help, Judge, if I answer that straight away, because we can cut this.
No, you can't wait. I think no, you can't.
I can wait. That's very well, but I won't be doing that. So, you know,
yeah,
we need not waste time on that.
This must be there.
So, Your Excellency has the broad point that I make in relation to these grievances. What I was proposing to do before Mr. Sethi's interjection was first to look at the actual pleaded case and the list of issues and make some observations about that. Second, the only case that I want to take you to and make some submissions about is the HSBC and Gillespie case that my learned friend referred to. And then I want to make some specific points about each of the categories of documents, right, hopefully more briefly. The appraisal and Sitlani documents I can deal with relate to different claims, and I can deal with those relatively briefly at the end. So if we go to the particulars of claim, Your Excellency, and that starts at page 4 of the application bundle, and we're concerned here with in relation to the grievances, those 3 categories of documents, we're concerned, as Mr. Sethi's made very clear, with the race claim. The section on harassment related to race and or direct discrimination starts at page 17 of the bundle at section 6. And 6.1 has a heading, continuous act or state of affairs of race-related harassment and less favourable treatment because of race. And then it sets out underneath it, very clearly articulated, a number of specific allegations of discrimination from 6.1.1 onwards. The Khan grievance is referred to at 6.1.2. Where the allegation is that in 2016 or 2017, in fact, you've seen from the unredacted portions of the document, you've seen it was 2016. Mr. Khan raised a grievance and filed a discrimination complaint seeking to demonstrate a pattern of discriminatory practice, setting out that he'd witnessed the claimant being racially discriminated within the work setting. Claimant understands Mr. Khan set out it was unfortunate the claimant suffered such treatment despite being a top performer. Well, you've seen and the claimant's seen all of the material from the Khan grievance that relates to what Mr. Khan witnessed in relation to the claimant. And that's the extent of the pleaded allegation in relation to that. In fact, we say what's in that doesn't bear out what the claimant's case is, but that's a matter for trial. But that part of the document's been disclosed. You'll note that what you've heard about Dr. Dree and guerrilla comments about someone else are not pleaded allegations in this case in 6.1. We've got a 2017 allegation, so a year later, about a different person, Mr. Giesbert, making a remark to Mr. Adunye. So there are some pleaded remark. There is a pleaded remark about things said to Mr. Adunye, but that's it, not the two things that are later appear in the evidence. And then at 6.1.4, we leap on in time to 2021, when the redundancies are announced and about relocation. So the Khan grievance in any event was a grievance that was brought back in 2016, 4 or 5 years before termination of employment, by a gentleman of Pakistani origin, largely about his treatment, or not, or at least not about Mr. Lawal's treatment, because you've seen the very slender reference to Mr. Lawal in that grievance. There is no reference to the Atawogu grievance there. But as we go on through the particulars, 6.2 jumps to disability discrimination and harassment. That's none of these documents, as I understood it, are said to be relevant to that case, but that's also something that happened in 2016 that's pleaded. Then at 6.3, page 20, one has the heading misrepresentation and race discrimination. And this is about the intended closure of the business and the redundancies and relocation issues from February 2021 onwards, as you see. And there are various complaints made about that process that the court's going to have to determine, but it's not said that in 2021 there was some overarching toxic culture in relation to the bank. And then at 6.4, one has a complaint about going back in time, March 2020. So this is about the temporary closure of the relevant desk during the COVID crisis. And 6.5 then goes on to deal with no genuine redundancy situation. And excuse me, at 6.5.6 for completeness, there's an allegation that the bonus package offered in 2021 was unfavourable owing to race, or because of victimisation, or because of protected disclosures. So those are the facts that are said to amount to discrimination. The claims at page 25, 7.2, we see that the claimant relies on the discriminatory treatment set out above, i.e. in the paragraphs we've looked at. And then the rest of that sets out the legal elements. So this is not a claim where the claimant's pleaded case sets out to demonstrate, to prove or allege an institutionally racist organisation or a generally toxic work culture. If we look at the agreed list of issues, and that's in the application bundle at page 198, The claims at page 199, 10.2, detrimental treatment. Did the events alleged at paragraphs 6.1 to 6.4 of the particulars of claim occur? Those are the paragraphs we were just looking at where the allegations are set out. Was the claimant subjected to detrimental treatment at those paragraphs of the particulars of claim? And over the page, harassment. Was that same treatment related to race? Was it unwanted? Did that 10.3.3, did that treatment have the purpose or effect of creating an intimidating, hostile, degrading, humiliating, or offensive workplace for the claimant? And then at 10.4, direct discrimination because of race, we see the questions identified there. None of those questions, all of the, I'll rephrase that submission. All of those questions require specific engagement with the specific allegations of treatment that are raised in the particulars of claim, not a wide-ranging inquiry as to other complaints that are said in some way, true or not, to contribute to what Mr. Lawal goes on in his witness statement to describe as a toxic culture. If I turn, so if we look at what the court's got to determine, the matters raised in the grievance, insofar as the claimant was treated in a particular way by the bank, he's going to give evidence about that himself. Insofar as Mr. Khan touches on that, he's got the evidence in relation to that. But what the claimant really wants these grievances for is to see allegations of how other people were treated to support this broader argument that it wants to run. And that, we say, is not within the scope of what this trial is here to determine. That brings me to HSBC and Gillespie. And I want to make a couple of points in relation to that, but particularly in relation to the submission that Mr. Sethi made about paragraph 20 in relation to background evidence and the like. But Your Excellency, if I can just go through, I just want to set the context of what was going on in Gillespie. Gillespie was an application to exclude from the evidence in the case background matters that were pleaded in the details of claim in the case. Yet even though they were pleaded, the Employment Appeal Tribunal decided that they were not sufficiently relevant to the issues that the tribunal had to decide, so it excluded them from the evidence. And that's a different case to here, of course, whereas I've just illustrated, we're talking about documents which the claimant wants to rely on as evidence to support matters that aren't even pleaded in the case. And the reason that I say that it was about exclusion of pleaded material, we can see in the report, if one looks at the judgment of Mr. Justice Underhill, as he then was, starts at page 482 of the application bundle. At page 483, and sorry, at paragraph 2, which starts on 482, the judge describes the history of the case and the nature of what's pleaded. Down the page near, just under F, you'll see that he records the details of the claim are very clearly and carefully pleaded. For present purpose, I need note only 3 points. And then at 3, which is over on page 483, he says paragraph 24, that's paragraph 24 of the details of claim, set out a number of further acts of sexual harassment which are said to have occurred while the claimant was working in the Far East between 91 and 2001, together with one incident which occurred while she was in Chiswick. These are pleaded as being relied on by way of background. The status of the allegations is the main point in the appeal. So that was what this appeal was about, whether the employment tribunal judge below was right to exclude the allegations in that paragraph. And at paragraph 9 of the judgment, page 484, What did paragraph 24 of the details of complaints say? Well, the judge tells us that at paragraph 9. I need not set out paragraph 24 of the details of claim in full. It's headed background in relation to sexual harassment complaints. It starts, and then it quotes from the details of claim. The claimant will further rely upon acts of sexual harassment that she was subjected to when posted to other departments before she moved to the group risk department in London as background in relation to her claims of sexual harassment in that department, as they reflect a culture within the organisation in which discrimination is wide place and or which is tolerated or not properly tackled, similar to what the claimant says in this case. Mr. Justice Underhill deals with the relevant principles on exclusion of that evidence at paragraph 13 of the judgment, page 486. Mr. Sethi took you to some paragraphs of this, but I'd just like to draw your attention to a couple of other points, if I may. You'll see under paragraph 13 on page 486 that the points that Mr. Justice Underhill summarises, he numbers starting with 1 through, I think, to 10. Mr. Sethi took you to 1. The basic rule is that if evidence is relevant, it's admissible, and if it's irrelevant, it's inadmissible. But he didn't draw your attention to 2, if I may. Crucially, for present purposes, relevance is not an absolute concept. Evidence may be, as is sometimes put, logically or theoretically relevant, but nevertheless too marginal or otherwise unlikely to assist the court for its admission to be justified. And then quotes a passage from Lord Justice Hoffman in the earlier case of Vernon Bosley. And then at 3, although there may be some divergence in the authorities as to whether the exclusion of evidence in such cases is to be described as being on the basis that the evidence in question, properly understood, is not relevant at all, or rather is not sufficiently relevant. And he goes on to say that the language of sufficient relevance gives a better idea of the nature of judgment required, which of course chimes with, on a specific disclosure application in this court, what the provisions of part 28.8 say about sufficient relevance. Mr. Sethi then took you to 7 in support of an application that inadmissible evidence does get in front of courts and tribunals all the time without being excluded, and cautions against making the decision at an early stage. And I agree with him that in any case, there's a case management decision to be made as to whether exclusion of evidence is best dealt with at trial or at an early stage. However, at 8, Mr. Justice Underhill says, notwithstanding the general position stated at 7 above, there will be cases where there are real advantages in terms of economy, in the broadest sense of that term, in ruling out irrelevant evidence before it's sought to be adduced, and more specifically in advance of the hearing. And there are 2 different types of situation that he then flags. The issue of relevance may be central to an interlocutory order which the tribunal is being asked to make, for example, about witness orders or disclosure. And of course, that's this case, you are being asked about disclosure. So now is the time to grasp the nettle on disclosure. In such cases, a wait and see approach will generally not be practicable or fair. But it may also come up by way of a frank application to exclude evidence as a matter of case management. For example, where if the evidence in question is called, it will seriously affect the estimate for the hearing, or where its introduction might put the other party substantial expense or inconvenience. And then we get to the passage that to 9. I don't think Mr. Sethi took you to this. I went to 10. And this is relevant to paragraph 20, which he did take you to, which I'll come to in a moment. Discrimination claims constitute a particular class of case in which it may, and I emphasize may, be appropriate to decide questions of admissibility in advance of the hearing. It's notorious that there's a tendency in such cases for claimants to adduce evidence of very many incidents of alleged ill treatment, often extending over long periods of time, and this can lead to very long hearings, which can put an enormous burden both on the parties and on the tribunal, and carry the risk of essential issues being obscured in a morass of detail. And that, of course, is a key concern in this case, that the court will be presented very late with a morass of detail of other allegations that will just obscure the actual issues that it needs to determine. I want then the other passage that Mr. Sethi referred to was at paragraph 20, and that's on page 493. Just to set some, I'm grateful, just to set the context before looking at 20, in the prior paragraph on the same page, 19, Mr. Justice Underhill said, I turn therefore to the question of relevance. In my judgment, the paragraph 24 allegations are not sufficiently relevant to be admissible. So his remarks at 20 were in the context of a case where he was his actual decision was to exclude the paragraph 24 allegations, even though they were pleaded as not being sufficiently relevant. At 20, Mr. Craig's essential case, Mr. Craig was the counsel for the claimant employee. The relevance of the background allegations is not that they cast light directly on the conduct or motivation of individuals against whom allegations are made in paragraph 20, but that they reflect a culture within the organisation in which discrimination is wide-place. And then there's a perhaps characteristic of Lord Justice Underhill's comment on the use of language in the square brackets, which we can pass over. It's unnecessary when one reads the word culture in this context to reach for one's revolver, but it is nevertheless an imprecise term and needs to appreciate how an allegation of a discriminatory culture fits into the proper legal approach. In a case of direct discrimination, the ultimate question will always be whether the claimant was treated in the way complained of by one or more individuals on the prescribed ground, or as we'll soon be saying, because of a protected characteristic. Where there's a dispute about whether a particular act complained of occurred or whether they were done with a discriminatory motivation, proving that, say, sexist behaviour or talk was common in the workplace, which is essentially what a discriminatory culture means, may well assist in the determination of that dispute, though it shouldn't be allowed to distract from the tribunal's ultimate focus from the particular acts complained of. In harassment cases, it may also be relevant in another way, inasmuch as a discriminatory culture may be acceptable synonym for the statutory language of a hostile, degrading, or humiliating or offensive environment. So, Your Excellency, the points that I would make there is that the emphasis even in those paragraphs is about proving the facts of the culture. And proving the facts of the culture in the context of the pleaded allegation, factual matters that are said to give rise to that culture. It's not a carte blanche to label any range of unproven allegation as contributing to a culture. That would be for the claim to pull itself up by its own bootstraps. Forgive me, Your Excellency. I'm just going to. Do you mind if I mute for a moment and just clear my throat?
Yeah, no, yes, please.
Forgive me, Your Excellency. The weather has been so unremittingly bleak over the last few weeks in this country that I'm still trying to shake off a chest infection. If I can just take a moment just to pause and regroup, and then I'm going to move on to some different points. So, Your Excellency has my skeleton. I've made the points that I want to make about the grievance as a whole, primarily by reference to the Khan grievance. But I want to turn to make a couple of specific points about the Adunye grievance and the Atawogu grievance. I deal with Adunye, paragraph 30 of my Skelly, which is at page 577 of the application bundle. It's a similar point in relation to Khan, the most that the Adunye grievance documents would show is that Mr. Adunye made allegations in a grievance, and that subsequently, when he was not happy with the outcome of that grievance, led to litigation in this court, which was compromised. It's impossible to evaluate the merit to attach to any of that. The claimant relies, though, on a slightly separate point here that doesn't arise in the Khan grievance, which is that Mr. Houghton, who dealt with the claimant's own grievance, said that the claimant's grievance had a lot of overlap with Mr. Adunye's grievance. Well, the question then is, well, where does that take us? And why would the court need to see the Adunye grievance if that were right? In the course of his investigation, Mr. Houghton, and the court has his investigation report into the claimant's grievances, interviewed Mrs. Amoulan, who was the person who conducted Mr. Adunye's grievance, and the minutes of what she said about the Adunye grievance formed part of the claimant's own grievance, and the court has them, the claimant has them, so that material is there. Insofar as Mr. Adunye complained about the same facts as the claimant complains about, well, the claimant's giving his own evidence about what happened to him and what he's complaining about. But insofar as the claimant wants to rely on other matters raised by Mr. Adunye in his own grievance, that is one outside the scope, apart from the too exotic remark, that's outside the scope of the pleaded case. And in any event, the court faces the same difficulty of trying to evaluate what weight to attach to any of those matters. The Atawogu grievance, again, raises the same set of issues. She, as I understand it, was based in the London office, not in Dubai, and was not a senior manager, although, as I understand it, she was of Nigerian background. There's nothing in the particulars of claim about that. In his first witness statement for trial, the extent of what the claimant says about it is that a colleague of his, Mr. Anim, at some time in 2019 or 2020, told the claimant that Mr. Atawogu had raised a grievance about racially derogatory slurs. That self-evidently, in my submission, what happened in 2019 in London between people who are not otherwise involved in the case, as far as one can see, has no relevance to the matters that the court has to determine. So all of these grievances in my submission are not sufficiently relevant to the court's determination. They risk placing the court either in an investigation of uncertain scope on a trial that's already tightly packed, or of proceeding in attaching weight on untested allegations that it's going to be very difficult for it to assess the merits of, or put out of its mind. So disclosure should not be ordered. I will deal with the performance appraisal and the Sitlani documents more briefly. The performance appraisal documents go to earlier years than 2021. The complaint, according to the claimant that they're relevant to, is the bonus for the year 2021, where he says he got a less favourable bonus than other colleagues in 2021 on unlawful grounds. We don't resist the production of the appraisal strongly, but at this stage out from trial, I do think it important with respect for the court to consider, well, if this matter is going into evidence, what use is going to be made to it, and how is it going to assist the court, given the very many issues that the court's got to determine over the course of the trial. It's worth looking at how the matter was put when the documents were sought. Page 213 of the application bundle, there is a schedule which sets out the claimant's document production request and the defendant's response to it. The appraisals were sought at page 224, item 20. All that was said about these documents is that you can see at 20, all appraisals on the claimant's performance. The claimant's argument was relevant to show the claimant's skill set. Well, that's not an issue in the case. What his skill set is and what work he might be suitable for isn't something that needs to be determined. So there was no basis when sought for the documents to be provided. And you'll see the next column sets out the defendant's objection. Moyo 1.
So you're not denying the claimant is a skillful employee for the previous years?
Well, I mean, skillful is not a yes or no thing. I mean, Mr. Setti is right to say that he had been well remunerated over many years, promoted, and indeed offered 2 promotions in the course of 2021. It's a bit difficult to see how that's going to support his race discrimination claim, given that his race was the same throughout that period of time. But that's going to be a matter for Mr. Setti to grapple with. In the Moyo first witness statement in support of this application at page 240, at paragraph 17, she says it's the claimant's position that the documents are highly relevant because the defendants put to proof as to why a high performer of black origin is paid a disproportionate amount in bonus as compared to his peers who are non-black. Well, higher bonuses in earlier years would seem to be inconsistent with a comparison on grounds of race rather than consistent with it. That's the way in which it was put. It seems to me it's now being put on the basis that it's really about victimization or whistleblowing, and the comparison with earlier years when no grievance or whistleblowing was raised. I mean, Your Excellency, we're in your hands as to that, as to whether the court will be assisted or distracted by seeing what the appraisals were in earlier years. But looking at the 2021 bonus on its own terms, it's the 2021 appraisal, not earlier appraisals, that are material. The last point is about the Sitlani role applications. And there's a total lack of clarity as to what claim this document goes to and how it will assist the court. The broad point made by Mr. Setti is that the claimant thinks that applications made by Mr. Sitlani for jobs in Singapore were in breach of Singapore Manpower Commission rules. The 2 points here are: one, that's not a pleaded case as to how Mr. Sitlani was treated. As Your Excellency quite rightly elicited from Mr. Setti, this isn't a discrimination complaint. It's not about difference in treatment between Mr. Sitlani and the claimant. The claimant's case here is one of misrepresentation under Article 12 of the DIFC employment law. And the pleaded position is at page 28 of the application bundle, paragraph 7.6. False representation in respect of misrepresentations as to the validity of the Singapore contract offered to the claimant. 7.6.1 says the claimant was misled in respect of the validity of the Singapore employment contract, pausing there, offered to him. That's what he's complaining about, a representation made to him about it. And the essence of it is that the bank said that the contract was valid, and he, the claimant, says that they were wrong to say that because the hiring procedure was in breach of the Ministry of Manpower guidelines. Now, that claim is either right or wrong. We say it's wrong. It's a matter for trial. The only material that's going to be necessary to determine that will be the contract that was offered to the claimant, the representations that were made to the claimant about that contract, and then an analysis of whether that contract in fact complies with the Singapore guidelines or not. What happened to somebody else, if it's the same or different, either way, makes no difference to that.
So we should not speak about culture at this level again. So this is not discrimination, not racism.
No, that simply doesn't arise in
nothing to do with culture, yeah.
No, nothing to do with culture. Doesn't matter. It's not pleaded that it was happening systemically or systematically or otherwise. It's an allegation that the claimant was misled in what he was told, because in fact there was a breach of Singapore Ministry of Manpower guidelines. That's the extent of it. So for that reason, we say that's simply not an issue that the court needs to go into, and consistent with the fact that it's Sitlani's application is neither pleaded nor relied on in the list of issues. So, Your Excellency, for those reasons, we invite you to dismiss the application. The only remaining matter that I need to deal with is another document that isn't actually subject of the application that Mr. Sethi introduced in the course of his submissions, although in fairness to the claimant, sorry, the survey. Although, in fairness to the claimant, I should say that that was intimated that it would be raised today in an email that was sent on Friday afternoon, I believe. But that makes no difference. That's very late and too late. And the broad point is, I mean, this is a fishing expedition par excellence. All one sees from the passage in the Khan grievance that we looked at is that Mr. Khan said, on the basis of what Mr. Lawal told him, according to his own grievance, that Mr. Nitzinger and Mr. Kern had been unfriendly towards him, and that a survey, I don't know at this stage exactly what that is, because it's only just been raised, showed unfriendliness towards other employees. It's very difficult to see how that document would shed any light on the issues that are relevant to the case. The claimants had the unredacted portion of the Khan grievance for some months now. If there was any weight to be attached to it, one would have expected it to have been seen. But the danger, of course, of disclosure, of production, is the same as in relation to the grievance documents itself. There may or may not be statements in that survey. Who knows whether one can tell who they're made by? Often in the nature of employee surveys, you can't. What weight's the court going to attach to it? It can't explore the truth or otherwise of what was said. So it runs the risk of attaching weight in the evidence that it takes into account in assessing discrimination on wholly untested and unprovable remarks in a survey made, well, on any view, no later than the spring of 2016. So those are my submissions, Your Excellency. Thank you for the time you've allowed me.
Thank you very much, my friend. I'll turn now to Sethi to rebuttal.
Thank you, Your Excellency. Repetition of my submissions aren't going to add to their force, but I'm going to just deal with a couple of principled points. And I'm going to be absolutely precise, I hope, so that there's no longer any confusion, because I was surprised that, given my clarification of my position, that my own friend still thought that, as he does, about what our position is. So let me make it quite simple and quite clear. The defendant's witness statements, as exchanged in November and December, in December, positively state that there is no discriminatory culture in this workplace. Okay. Now, we propose that there are obviously sufficiently relevant documents which might well assist the claimant's case of establishing a discriminatory culture. We will be testing the defendants' witnesses on credibility of that assertion, but also on their knowledge of allegations that a number of people have made, which are similar to the allegations or same as the allegations that the claimant has brought to trial, which are the only allegations that we will be inviting the trial judge to make findings and conclusions on. We will not for a moment be inviting the trial judge to conduct a trial within a trial of other people's race complaints. Not at all. Let me be absolutely clear about that. The second point is that the mere fact that other people have brought grievances is not the point that we are relying upon. The truth of those other grievances is not the point we are relying upon. What we are relying upon is for the court to read and for us all to see what the grievances said, what the allegations were, what the complaints were, regardless of their truth. Why are so many senior black or other non-white managers, senior managers, responsible senior executive people making serious written grievances of race discrimination at this time? That is relevant. That is probative. It's not about the court guessing. The court is making findings of it. The court will make a finding, for example, or could make a finding of fact that at about the same time as the claimant was complaining about manager X making a derogatory race comment, other people were also complaining about manager X making similar derogatory comments. Now, that fact, the fact of other people making similar complaints about the same manager at the same time, about the same kind of thing, is highly probative of an admissible evidence upon which a tribunal or court can draw findings of fact, the existence of other similar complaints, albeit not determining those other complaints, as probative of the veracity of the claimant's causes of action as pleaded in his particulars of claim. And I hope I have been crystal clear that the relevance and the use, my learned friend kept saying, what use will be made of these documents? Well, I'm telling you right now what use is going to be made of them. And I hope there is not a shadow of any doubt about that. Now, the defendants will have conducted investigations, as my learned friend has confirmed to you. We don't know. He's giving us evidence about this, that they've conducted investigations and reached outcomes. Reports. Well, we should be able to see those because they will detail what, at least from the defendant's point of view, were their findings on the 3 employees' allegations of race discrimination. And that is relevant probative evidence. Now, the court and the claimant, Judge, this is very important because we've heard a lot of hints as to what these grievances may or may not contain. But the court today and the claimant simply do not know and will not know the content of those grievances precisely until they are disclosed and in unredacted form so that the court and the claimant can read them. What we do know, though, this is not a fishing expedition, because what we do know is that there is a lot of overlap according to the defendant's own grievance manager. And I take you to trial bundle page 1170. Mr. Richard Houghton was appointed to investigate and decide the claimant's grievance. At the top of 1170, paragraph number 1, R.H. Richard Houghton started by giving a short summary of the topics at hand. He has been appointed as grievance manager for a grievance filed by Mohammed Lawal that has a lot of overlap with the grievance by Chris O'Donnell that SZ has investigated recently. Therefore, it made sense to get SZ's input instead of asking the same questions to the same people. Now, so this is not a fishing expedition. We know from their own words that there is, quote, a lot of overlap between the 2 sets of complaints. That in itself, Your Excellency, that in itself would, we say, provide sufficient relevance, materiality and force to the submission that this matter needs to be before the court. And of course, we made the point about testing even the defendant's witnesses' credibility as to their suggestion that they are not aware of any kind of discriminatory culture. Now, so I want to just repeat, we're not relying upon the fact that other people have brought just grievances. It's what the grievances were about, and you need to read the grievances to understand the nature of the allegations. And of course, we will get the defendants' response to that and their decisions and investigation reports on that from at least their point of view. Nobody is suggesting that we are going to be reopening those other grievances and trying to have a trial within a trial. And any trial judge will be very alive to the need to ensure that that doesn't happen, and that won't be invited either by myself. But as I say, the nature and the content of the grievances is critical. What were they complaining about? What is the overlap between Mr. O'Donnell's grievance and the claimant's grievance? That's what we want to know. So, Judge, I hope it really does explain the importance of this matter.
Well, I think there is one point remaining, which Mr.
Yes.
Mansfield says, even if someone to take your case at the highest, you
Yes.
still have no ground in, let's say, companies' collective culture for racism and discrimination in your main pleading, apart from your evidence.
Let me deal with that. The first point is this. I do say it is in the pleadings. The pleadings give rise to the case that we are relying upon a background of toxic discriminatory workplace culture. Okay. But before I go take you to the pleaded case, let me say this, and I say this advisedly. In all, it is not necessary to plead a discriminatory workplace culture in a discrimination claim in order to rely upon evidence of a discriminatory workplace culture. And the reason for that is because, as Mr. Justice Underhill said, as he then was in the Gillespie case at paragraph 20, he said the court's focus has to be on the causes of action. But he said, do you recall, Judge, I think it's worth going back to that. It really is, paragraph 20. It's in the today's hearing bundle. At page 493. And what he was doing there, he wasn't focusing on the pleaded case in that case. He was giving guidance to courts and tribunals below about how the allegations or complaints or evidence or a discriminatory culture fits into the proper legal approach. That's his language, not mine. He says it needs to be appreciated. And I say the same thing on this application. It really does need to be appreciated how the claimant's reliance upon a discriminatory culture fits into the proper legal approach. And in a case of direct discrimination, the ultimate question will always be whether the claimant was treated in the way complained of by one or more individuals on the prescribed ground. And he says, where there is a dispute about whether the particular acts complained of occurred or whether they were done with a discriminatory motivation, and that, of course, is the pleaded case, because you're saying that I was treated to my detriment and less favorably than a comparator motivated by racial factors. That will be the cause of action that you need to plead. Evidentially, in support of that, you will rely upon a background of discriminatory culture, but you don't need to plead it. It is not a necessary pleading for the purposes of proving a direct race discrimination claim. It's an evidential matter. So my first submission is it's an error of law to require a claimant to, as it were, plead the words discriminatory culture within a pleading of discrimination. That's my first point. My second point is this: he does effectively do it anyway, because if you look at the nature of his pleaded case, I'll take you to references to it. If we wanted to see that the claimant does complain of a toxic workplace culture in the context of his causes of action. For example, I'll give you just because I'm in reply, and I'll be short. But if I take you to paragraph POC 6.1.5.
Page number?
That is on page. Page 19, I believe. 6.1.5, page 19. And we see there that he pleads that he contends there was a clear strategy by the first defendant to remove the claimant from the bank, whilst his peers were encouraged and assisted to remain within the bank. The bank allowed for a hostile work environment, included rumours being spread internally in direct breach of confidentiality, etc. And then if we look at another example in the particulars of claim, if we go to paragraph 6.2.5. And the question you got to ask yourself is, what is the claimant referring to when he talks about hostile work environment or a toxic work climate in the context of his claims here? He's obviously talking about a discriminatory culture. 6.2.5, the claimant avers the bank's discriminatory approach in relation to the claimant's disability is further evident when compared to the preferential treatment offered to his Caucasian colleagues, namely Mr. Davadian and Mr. Anstead, who were provided with an orthopedic desk and chair. Bank further failed in its duty to protect the claimant's health and safety by condoning working in an unsafe environment. And Judge, if you go to 6.1.2, 6.1.2 is on page 18. He talks about demonstrating a pattern of discriminatory practice, setting out what he had witnessed. This is in relation to the Khan grievance. So in other words, he's saying that Mr. Khan raised the grievance in which Mr. Khan was complaining about a discriminatory culture, a pattern of discriminatory practice, quote unquote. And then if one goes for, if you wanted a support for that, the evidence, as I say, you don't need to use the word discriminatory culture. It is clear from the nature of the claim that the claimant is relying upon a discriminatory culture because he's relying upon other people complaining also about similar things, such as Mr. Khan in his pleading. And Judge, if you go to page 109 of the trial bundle, and we're looking at here Lawal 1, paragraph 70. He talks about it upsetting him that an individual working in a multinational bank in a multinational country, I had to endure years of toxicity at my workplace.
Well, this is the witness statement here.
This is in the witness statement, there, Lawal 1, paragraph 70. And then if you go to Lawal 2, paragraph 13, page 190, 190.
Yes.
And one looks at paragraph 13. It is clear that the bank fostered a toxic workplace environment where employees were not reprimanded for open discriminatory practices. It was an ongoing problem at the bank and was raised several times with senior management. Employees such as myself felt bullied and harassed, however, had no alternative for the sake of our livelihood. Now, the point being made here, so the 2 points are that first, it's a non-issue to say that it's not pleaded. It is pleaded, but even if it was not pleaded, expressly as a discriminatory cultural workplace, it would not be necessary to plead it. And to determine that it is necessary in a discrimination case for a claimant to be able to rely upon a discriminatory workplace culture, he must plead it. In my respectful submission, that would be an error of law. And what nobody wants in this case, given the importance of this first discrimination case in the CFI, for there to be delays and other interlocutory appeals on matters of disclosure. What is sensible and appropriate here is to err on the side of caution, as Mr. Justice Underhill says. Once the trial judge, who I believe will be yourself, has seen these documents, perhaps then you, like me, will be in a better and more informed position, rather than risk interfering with the course of justice here and not serving the overriding objective. But let me stop there. I'm grateful.
Thank you. Final word, Mr. Mansfield? Or you're done?
Just one point, if I may, Your Excellency, in relation to that last reference to Mr. Lawal's witness statement, in which he complains that the bank failed to take proper action about the complaints of other people's grievances. That, of course, depends upon the proposition that those grievances had substance. If the grievances didn't have substance, if the allegations weren't true, then the bank wouldn't have any action that it needed to take. So once again, Mr. Sethi, with one hand, tells you that he's not relying on the truth of these allegations in the grievances, but his own client's evidence and it clearly indicates that that's what he intends to do.
Thank you very much. I think I've heard enough from both of you, which I thank you for. I shall reserve for judgment, but not for long. I will deliver my judgment tomorrow. I will take this afternoon because it's 4 o'clock Dubai time. I'll try to spend the next 2 hours, 3 hours assessing your case, and tomorrow morning you shall have my decision. I'm sure with the brief reasoning, because the matter of we need to do it in an urgent basis. That's one thing. And then the day after, I do involve in a hearing. And yeah, it will be very difficult to write detailed reasons in this relation. But the promise is that you will have my decision tomorrow about the production of documents. Along with cost. I don't think you need to plead a cost because cost would follow the order. Clear?
Thank you very much, Judge.
Thank you, Your Excellency. Yes.
Thank you. Have a good day ahead.